Good morning to all of you. Let me welcome the members of this inquiry. We're here at M46 and on a virtual platform. Recognize and welcome the public protector at M46 and her legal team, led by Advocate Mbofu, the evidence leaders, Advocates Mayosi and Bawa, members of the media with us, our entire support staff. Last but not least, the members of the public, the various platforms. You're all welcome on this day, the 1st of March, 2023, as we continue with our work of the inquiry. Today is a new day, not just being the first, but also to get to the next witness of the program. Just want to check honorable members on the platform. Honorable Lothridge, can you hear us? Honorable Olumisa, welcome back. Can you hear us?
Yes, I can hear you, Chairperson.
Welcome. Thank you.
Apologies. Busy with the papers for the load shedding for a case which will be heard on the 20th of March. But I'm around.
I didn't get the date.
20th of March.
What about it?
I say to you, I've been away and busy with preparing for a case on load shedding where we are challenging the government, ESCOM.
Oh, okay, okay.
That for 20th of March.
No, that's understood, Honorable Olumisa. So that's a court date. Thank you. So our system is working that we can hear each other. It's just I was testing the system. Thank you very much. We now, honorable members, going to start proceedings. I'm going to recognize Ms. Fatima Ibrahim.
Chair.
Just before that, I see Advocate Mbofu.
Thank you, Chair. Now, I'm assuming when you mention Ms. Ibrahim that you're about to swear in the witness. So I know that. So I thought that there's something I want to raise before the witness is sworn in. It will happen. We're not stopping the swearing in of the witness, but we just don't want to interpose that issue when once the witness has been sworn. Okay. Thank you, Chair. Chair, we received your letter. I don't know what time, but sometime overnight. Yesterday, and I think after that, then we also had occasion to watch the proceedings from yesterday, and therefore we have been instructed to just respond to both the letter and those proceedings. Chair, I think I must just say that both the letter and your proceedings were received with a lot of pain by our client, because and also watching what was being said about her in the YouTube broadcast, from which we were once again excluded from the discussions. And so we were helpless as we watched the rules of the committee and the directives being violated left, right, and center. So that's why we wanted this opportunity just to respond to some of the things that were being said about the public protector or her legal team. Because it looks like to her, the slogan, "Nothing about us without us," doesn't apply, because she was being discussed in her absence and without her input, and all sorts of conclusions being made about her, which just violates even her rights as a citizen, because this is her parliament as much as it is mine or anybody else's. And she should have been allowed to participate, even just not so much as the subject matter of this committee, but as a person. Chair, one of the issues, I want to address all the issues that were raised both in your letter and in the meeting, except the ones that are pertinent for now, for this witness. I just want to indicate, Chair, that, well, you effectively ruled that the 7-day rule does not apply, or if it does, you said you're going to relax it. And we will address that matter more squarely, I think, after the evidence of Ms. Madonsela, when we have to react to it, because firstly, we don't agree that the 7-day rule doesn't apply. We also don't agree that any good cause has been shown to relax it. And in any event, in our view, if that rule doesn't apply, then the directives are clear as to what should happen in other exceptional circumstances. But Chair, if you allow me, can we park that issue, as I say, because we don't want to delay your program.
You can just indicate how many minutes you need to just place.
For now.
So that I don't panic.
Yes, no, don't panic, Chair. I'll need 30 minutes, less, maybe 20.
Okay.
From now.
That's fine.
Yeah. Thanks. I'll try and aim for 1/2 past.
That's granted.
Yeah, okay. So Chair, and that's why I'm doing it like this, parking certain things so that we so that's the first thing, Chair. The second thing is that you personally said that the reason why there was a delay in this statement of Advocate or Professor Madonsela was because of delays which were caused by the public protector and her team. We just want to demonstrate that there's nothing further from the truth. And if you allow me, Chair, instead of reading from the letters, I'll paraphrase. So unless if there's, just to save time, unless if there's something specific, we'll then go to the letters. But let me just quickly paraphrase what happened, Chair. We, as you know, in I think November and December, made an application for Professor Madonsela to be called as a witness for the public protector. We outlined the areas where we needed her assistance in a letter dated 14th November 2022 and in another one dated 13th December 2022. Then what happened is that the committee ruled that that application would be successful. In other words, she would be summoned. But it so happened that without the knowledge of the committee, I suppose, she had written a letter objecting to this and the other about relevance. And at that point, the committee then I don't know what's the best way to put it, but basically then hijacked our witness to be the witness of the committee. That's fine. We didn't complain much because the committee, the witness was going to be called anyway. But in that process of hijacking, then the scope of what we had required was narrowed. That's fine. Even that we thought we could live with, because we would get maybe not everything we wanted, but at least some of it. But then what happened then, Chair, is, which is the part that you then blame the public protector for, is completely something that is totally uncalled for, because the former public protector, at least, wrongly blamed us for having, I think the word she used was forbidden, for having forbidden the evidence leaders, sorry, from consulting with her, which we had not done. And in fairness to the former public protector, she apologized in a subsequent letter for that. And I think the Secretariat clarified that was wrong. It was a wrong accusation. We had never done such a thing. And we accept the apology of the former public protector in that regard. And because all we did really, Chair, was to say to her, since originally we were called by us, we would like to consult. And as you know, we can't force her to consult. So, and she elected not to consult because she wanted only to consult with the evidence leaders, because she said there was a tradition to that effect, to which we explained that that tradition doesn't apply here. This is an unprecedented process. It has its own rules, and there's no witness who has, at least until that point, who had not done a statement with one or the other party. Anyway, as I said, the apology was made and accepted. Then the former public protector wrote to us and said, this committee has confined her evidence only to CX. And we must indicate other areas that we're interested in. I suppose.
And Friede.
No, I'm doing this. Yes, she didn't say and Friede. Yeah. She said it was only CX. Yeah. Sorry, Chair. This was about 2 weeks ago, yes. But we did exactly what you're doing, Chair. We assisted her, for which you are blaming us. We then wrote back to her at her invitation. She said, I'm only asked to deal with CX. And if there are any other areas, please indicate, right? So we wrote back to her, we said, no, firstly, you're wrong. It was not just CX that the committee has indicated. It was CX and Friede. But in addition, in response to your invitation, these are the other areas that we're interested in, seeing that you don't want to consult effectively. Yeah, I'm paraphrasing again. Yeah. And we listed those areas. Including issues which I'll deal with now about Mr. Siabi. You'll remember all the issues that were raised where she was specifically mentioned. So we listed those areas. Now, then she came back and said, and we even invite in that letter, we said, just as a matter of courtesy, we also want to indicate to you, not just the Friday, not just the invitation, but also that there's something called the 7-day rule. So please, if you're going to be testifying on the 1st of March, the statement will be expected on the 22nd, I think, whatever the 7 days is. Well and good. The statement did not come on the day that it was due. She asked for an extension, which you granted, and the statement came on the Friday, which rather on the Saturday, sorry, the 25th, yes, 25th of February. So how that becomes the fault of the public protector or her team, when all we did was A, to assist, B, to indicate, to respond to the invitation by the former public protector, to indicate what other areas, and C, even to correct her that it was just CX, it was also Friday, is something that really is not just hurtful, but gratuitous. So that's how that delay happened, Chair. And therefore, we could not benefit from the 7-day rule. We could not even benefit from the other rule that allows us to prepare for reasons that I will explain later, probably in the afternoon. And now it was being portrayed here yesterday as if the public protector, I don't know, does not want the witness. How could she not want the witness to testify when she's the one who called the witness originally before she was hijacked? So that's another completely unfair accusation to the public protector. Then, Chair, you also went on to say yesterday that we were, I don't know what you called it, like a double delay. We were proposing that Mr. Matabucha must be subjected to some double delay because of the deferment the last time and any further deferment. But that was a completely unfair accusation as well, because actually what we were proposing, as far as Mr. Matabucha is concerned, was to bring him forward. So we're not proposing any double delay. He's supposed to testify on Friday, and we had asked for two things. We said, please bring him forward, make him earlier, not later, and call him on the 1st and 2nd, which is today and tomorrow. So how that becomes a double delay beats me. And the second thing we asked, as far as Mr. Matabucha is concerned, is to say that we think we'll need him for 2 days rather than 1 day. And that was not even addressed in the meeting. And the reason for that, Chair, is not because we want to delay, obviously, because we wouldn't bring a witness forward if we wanted to delay. We would defer them. But the reason for asking for a longer time is just simple. Mr. Matabucha is going to, it took us a day, we even struggled with that day to deal with Ms. Mviane, who's only testifying about the rogue unit report. Mr. Matabucha is testifying about the rogue unit report and 3 other reports, CR17, Busasa, Friede, and Pillay. And from the experience of Monday, it was clear that we're not going to be able, if we couldn't fit Ms. Mviane in 1 day when she's only dealing with 1 report, then it's not going to be possible to do the justice to Mr. Matabucha. Sorry. That's an actual so sorry, Chair. Okay, I'm going to need more time, but not much more, Chair. So that's the second thing that you said in the meeting. And again, because we were excluded in the meeting, we couldn't correct you from doing those things or even overlooking that request or dealing with it one way or the other. So it was in that context that we wanted Mr. Matabuko to move to the first and second, because we would have been bringing him forward and also catering for the 2-day request. Right. Then, so Chair, then you then allowed yourself once again to be misled by the legal services or secretariat or whatever they are. Because when we raised the issue of the other witnesses, that we said, these are the witnesses that we intend to call. The 3 categories, these are the witnesses we intend to call. These are the witnesses that would ask you to please subpoena. And then the other witnesses we're asking for you to recall. And you were told that, no, you discussed this thing in October and there's no need to revisit it. And that's what was the decision. But that misses the point completely, Chair.
You did say you will stay on issues on this witness. I wouldn't want you
yes,
to,
no. I'm just, okay, fine. Let me just flag this one then. That point, the point that is missed there is we know we were here. We don't have to be told that the issue was dealt with in October or that it is part of the litigation. We know that we are in that litigation. What we were saying to you was, due to the evidence that has now arisen, for example, Ms. Mvuyana has placed Mr. Kotan squarely at the center of this. Mr. Matabuko has done the same. We were saying, due to that, we will ask you to make a fresh decision on that point.
I want to ask you.
Yeah.
You indicated correctly at the beginning.
Yeah.
That you'll park the other issues.
Yes. Yeah. No.
So that the time that
no. Fair enough, Chair. I accept. I won't develop the point, but I'm just. I think it's important to put that perspective of. That perspective of where we were coming from with this letter, just so that you know that we're not crazy. We know that you made a determination in October. We know that I think you made another one in November or whatever. But we were saying, due to the obvious need for those witnesses, if you are fair, you could reconsider and say, now maybe we made that ruling. Maybe it was a correct ruling at that time, but now can we really not call those witnesses? And that's what and you could have come to any decision, yes or no, doesn't matter. But to refuse to entertain the issue because you made the decision on October is just unacceptable completely. Then, Chair, as you correctly bringing me back into line to deal with the specific issues to do with this witness. The crux of the issues with this witness, Chair, is that again, I don't know, the level of prejudice and bias against the public protector is just is difficult to stomach. This witness was supposed to come here today and tomorrow. Monday and Tuesday were not scheduled days for this commission, for this inquiry. And we would have had the opportunity, therefore, even if the statement was late for argument's sake, we would have had the opportunity to prepare on Monday and Tuesday, according to the original schedule. What the public protector did of her own volition to meet the committee halfway and to meet the request of the evidence leaders was to agree to interpose Ms. Mvuyana for Monday and Tuesday. That was not the plan. I don't have to go through the history. You know the story about Ms. Mvuyana and the fact that she wanted to make a statement and so on. And we then compromised. We said, fine, if so that the program is not affected, we will interpose Ms. Mviana on Monday and Tuesday. And as a result of that, Chairperson, the time which we would have used to prepare for this witness was then used to assist the committee with its program. But no, that's the fault of the public protector. She's the cause of all the delays, and she's the cause of the seeking time to justifiably to prepare for the next witness. And all along, Chair, the unfairness in this is that you and your committee are fixated with the rigidity of the program. Yesterday, one listens with pain on YouTube, member after member is saying, no, we can't grant this request of the public protector to give time. Why? Nobody mentions the public protector. Nobody mentions the issue of fairness. No, it's all about, you know, we have so many committees. We sit in so many committees. We have so we have this burden. The committee has a program and members have a lot of work. The person to whom you owe a duty of fairness is not even mentioned. It's all about you and your programs and your committees and your many committees and all that. When we're making a reasonable request to say, having been denied an opportunity to prepare because we're accommodating you, can we bring one witness, basically swap the witnesses? We're not saying don't sit, we're not saying postpone, we're not saying anything, we're saying swap the witnesses and accommodate us. No, that is just reason for us to be insulted. So Chair, that's really the objection that we raise, that to now blame the victim and the person who's been trying to assist you with your program and even assist the witness is just unpalatable. Let me just, the letter I was referring to, Chair, is the 23rd of February, 2023, I think that's Thursday, from Professor Madonsela to us. And paragraph 3F of that, where it talks about whether the evidence leaders have forbidden her and so on, where we had said to her, it's false that our team has ever forbidden evidence leaders from assisting you with a statement. Please indicate to us who advised you of that non-existent fact. Then she says, I concede that I may have misunderstood why my plan to be assisted by the evidence leaders, her plan, on Monday, 20th February was scrapped. I apologize for communicating my misunderstanding as a fact and retract the assertion. And as I say, we accept both the retraction and the apology. But what we don't accept is to be insulted for it, as if it was our fault. And that's therefore the genesis of the delay, Chair, of why the statement came on Saturday. It's because of those two things. Her response to our response to her invitation, as it were. Yeah. In relation to the other issues that we did raise, and this is pertinent to what I'm going to say now, Chair. In relation to the issues that we raised to her outside of FRED and CX, she then asked a series of questions and we responded to say, no, we're not going to answer. You know, there's no point in having now the committee sitting in writing in letters going up and down. We'll ask whatever questions, she'll answer them, or if she's not clear, she'll answer them here in committee so that you can rule if whether our questions or her questions to us are to be answered. And I think that's where we left that issue of the extra issues. But the pertinent issue is not even that. The pertinent issue is that we were denied an opportunity to prepare, because the thing came on Saturday. Sunday we were traveling and preparing for Ms. Mviane, and the last 2 days you all know. I'm now told that there's a new statement that has just arrived now at 10:13. An amended, edited statement of Professor Madonsela. I didn't even know about that. In other words, now while I'm talking to you, I have not even seen it yet. So, Chair, it is those issues that we want to raise for consideration by the committee, at least those that deal with this witness. The other issues, I agree with you. We're re-raising them and putting the context. You can deal with them in the committee at another time, or the issues about witnesses. But we demand to be given a response on those issues, positive or negative, rather than it being brushed aside as an October issue. But as far as this witness is concerned, what we are requesting you, Chair, is to consider the history that we've placed on the record, and at the appropriate time we will address you on the directives, on our interpretation of the directives. And let me say this, Chair, just so that it's clear. If we have no objection, well, subject to this thing of the new statement now, I'll ask for 5 minutes, maybe just before you swear her in, or even after, just to consult on that. But subject to that, at least when we came here this morning, we had no objection to her being led, for example. As to what happens when our turn comes to question her is a matter that I say I'll address at that point, yeah. But now maybe I don't know if you have the new statement. You don't? Oh, okay. How long? I'm told it's longer than the other one. 9 pages, which nobody has seen yet. So, Chair, I'll leave it in your hands. Maybe the 10 minutes might not be enough. Have you received it? Sorry, Chair. Sorry, Chair, I'm taking over your meeting.
No, I can see that.
I'm just, yeah, sorry.
It's not going to be too often I allow you to do that.
No, sorry, Chair. I just wanted to clarify myself.
Chair, I just needed to indicate that we would need time to just look, because I haven't had a chance to look at it yet.
Okay,
you have it.
Just received.
Okay.
Yeah, otherwise we'll send it to you. That's fine. Thank you, Chair. Can we then adjourn, Chair? Then I'll when we come back, I'll then address you for a few minutes, one way or the other. But I think it's fair that at least us and the colleagues have a look at the new statement, because it actually might make everything I've said to be academic.
Thank you, Advocate Mpofu. I would have given you, you would have asked for 20 or so minutes, giving you more than that. The 30 minutes you asked, actually 35. Thank you. I think it's only fair that yes. Before that, Advocate Bauer.
Chair, can I just ask one clarification? The evidence leaders is under the impression that Advocate Mpofu is going to lead Professor Madonsela.
Okay.
Okay, I'm going to.
Chair, can I address that so that we don't waste your time when we come back? I'm sorry, Chair. No, well, that impression is wrong from the evidence leaders. As I said, it's not, again, it's blaming the victim of the hijacking now. Yeah, once the witness was taken over by the committee, then the rules are very clear that such a witness is led by the evidence leaders. And that's why we wanted originally to consult with the witness so that we could lead her, but we can't lead someone who
You've answered the question.
Okay, thank you, Chair.
Advocate
But-
Bauer?
we can
Yeah.
postpone that.
Chair, the witness was not taken over by the committee. So the witness, Advocate Mpofu asked for the witness to be subpoenaed. The committee agreed to accede to Advocate Mpofu, to the PP's request for the witness to be subpoenaed. In the course of that, the witness said, you don't have to issue a subpoena. I'll come willingly pursuant to the PP's request for her to come. She then did not want to consult with him. That did not, and because of that, we did not consult with her because she was a PP's witness.
No, Chair, well, it looks, I'm sorry, maybe Ms. Bauer was not, doesn't have access to YouTube. I think yesterday every member said that this is our witness and we have called her and therefore the other rule doesn't apply, whatever. But no, it's fine. We'll sort that as well during the break there.
Okay.
Chair. Thanks.
No, before we make Miss Nomkosi Madonsela an orphan.
Nomkoso.
So because I can see now she's now become an
Offense.
an orphan even before she takes the stand. I will just for as an apology to everybody, including our witness who will be introduced, for the delay in this proper or actual start. We will take a break. I think it's only fair that I was in any case going to do that after I would have spoken, but it's fair that we accede to that. We'll take a quick 15-minute break and be back here at just about 5 to or so.
Chair, can you make it 15:15, please? It's 15:45 now.
Okay. So
because
we'll
if I have to
we'll
read a
take
9-page
a 15-minute break and be back at 11 at least.
If it was 15:11, but can you make it more? I need to read that 9-page statement,
Okay.
among other things.
Is
Slightly.
that in order, members? Can we do that? There's a extra 15 minutes request for a break. Come on, come Advocate Bauer. I'm giving you an opportunity. Okay, so I think the 15+ minutes would assist. So would be, I accede to the second request. We'll resume at 15:15. You must be very lucky today.
Yeah, no, I'm shocked. Thank you, Chair.
colleagues. We had that extended long break, and I hope that it has assisted us, perhaps with how we now need to outline what happens next. I want to, so that members are interactive on this matter, to just having listened to the presentation by the PP legal team, to put up front what we think should happen, and then have members engage with that, and then we conclude on it. The following issues are now placed on for your consumption and decision, members. You all have heard and listened to the concerns that were raised by the PP legal team, and from the chair. All of those are welcomed and noted. Specifically on the witness for the day, Advocate Tulisile Nomkhosi Madonsela. As I heard somebody say Nomkhoso.
That's what it says on the statement.
Her proper name is Nomkhosi Madonsela. That could have been a typo error. So colleagues, we've already lost some time since 10 o'clock in this regard. There would have been issues of statement, and I'll ask Ms. Ibrahim to speak to that in terms of whether the amendments go as far as changing the substance, or what the amendments are all about. But the first few issues I want to put that we want members to react to. One, we would have tried to do the following things, that given all of those challenges, both those that were placed by the PP legal team and the slight matter of the amended statement, whose nature is going to be explained later, that it will be proper, therefore, that we Advocate Thuli Madonsela as a witness stays over and not be done today and tomorrow. We would have considered Saturday and Sunday to do that. She would have been available, but the PP legal team would have commitments, prior commitments already. And the dates that we want to place here is that she's available on Monday, entire day on Monday, as well as half a day on Tuesday, meaning the 6th and the 7th. And that's the days that we want to put to you with the concession and flexibility that we consider that. Two, that we do not want to lose any time, that we use the time today from 1 o'clock as well as until tomorrow to have Mr. Matabuke taking the stand, who would have come on Friday. So meaning you do away with Friday. We have him today and tomorrow. There would have been a an arrangement that from next week, the 7th of March, would have expected the statement of the public protector to be submitted to the committee in preparation to the 15th of March. With this, that we give a leeway to that date and extend that date to the 9th of March for the submission of that statement, in order for us to be ready for the 15th of March to start the testimony with the public protector. We also, maybe before I ask Ms. Fatima Ibrahim, maybe to just explain to the members this issue of the statement. But I do want to also call upon Advocate Mpofu to clarify one matter. So not just clarify, but indicate where they stand on it. The witness of today would have been brought to the committee as a request by the public protector, and for subpoena or summons. And the committee acceded to that. So, because he did take us through about how, and he used a strong language, don't want to get to that language, that the committee hijacked his witness, which is not true. Which is not true. Maybe adopting might come closer, but still that one is not. The witness remains the PP's witness. This is what I want you to confirm when I give you the chance. So that if you are saying, please adopt this witness as a committee, then we know that. That's what is happening. So that clarity will be needed from your side. Ms. Ibrahim, just on the amended statement, I've not seen the statement, was busy with other things. Advocate Mpofu says it's now 9 pages and not 4 pages. Is that so? We're now having a 9-page statement compared to the 4-page statement.
No, Chairperson, I think the confusion came in because the pictures that were sent through contain the pictures of 2 affidavits. So the one without changes and another one that has changes that are made by hand. There is still some further confusion, which I'll get to in a moment, but in terms of the changes.
So it's not 9 pages?
No.
Okay, I won't ask him to retract and apologize.
No, Chair, we were all confused.
9
when it came
pages in total, Chair. She just explained to you. It's the old one and the new one.
In Advocate Mpofu's defense, we were all confused because when it came in, we quickly scrolled through it. So we can see where the mistake came in. But Chair, in terms of the changes made, they are purely grammatical, editorial type changes. And I think they're probably 6 or 7, but I'll give a few examples. So insertions of a full stop before Advocate Paul Hoffman's name, the insertion of the term advocate and senior counsel at the end of his name, the use of the word systems instead of systems. So it's those very minor changes, nothing that affects the content. There is some confusion, Chair, that I have requested Prof. Madonsela to just clarify for me, in that the changes made are made on the version of the 25th, which was the version that was originally submitted to the committee. But there appears to be another version without the changes, the content of which is exactly the same, which is the 28th. So I haven't received that clarity, but in terms of the content, I can confirm that the content isn't affected at all. It is just cosmetic changes. Thank you, Chair.
Thank you, Ms. Ibrahim. Now go to this side, over to you, Advocate Mpofu, and then thereafter we can invite the members. Thank you.
Chair, sorry, I'm just making a note of your earlier request. It was about the, let's take away hijacking. It is the adoption or otherwise of the witness. Okay, no, before I come to that, Chair, if I can just address this issue of the statements. Well, firstly, we welcome your ruling about not proceeding with the witness today, because the confusion is just immense. And if it makes you feel better, I retract and apologize over the 9 pages. But that's part of the confusion that was created. The 9 pages comes from the fact that, as Ms. Ibrahim indicates, we received, while I was talking to you, there's 9 pages which had the old statement and the new statement. But it's worse than the question of the new statement, Chair. And I'm hoping that the break will assist all of us. Either there must be a completely new statement so that we don't have to be having this kind of technical debates when she comes, or something. Because what is happening now is actually not just confusing, it's actually probably illegal. Because not only has Professor Madonsela changed her statement, there are now 3 versions of the statement. Version 1 is the one that you and I received on the 25th, which had some handwritten changes. Version 2 is a version where she put those changes that Ms. Ibrahim spoke about by hand, without changing the date. We don't know when that version was done. Version 3 is the one that arrived this morning, which was commissioned yesterday. And that makes it even worse. And it seems to be that that version 3 is now the typed version of version 2. But there's something fundamentally wrong and possibly illegal about that, because that version says it was signed in Stellenbosch, but it was commissioned in North Riding, Johannesburg, which is a physical impossibility. So either someone has broken the law, either the deponent or the commissioner of oaths, or both. But all those will be, because of the break, I'm saying, Chair, that those issues will be clarified with the witness, and if necessary with the commissioner of oaths or the police. So that issue will then take its own course. Yeah. Now, coming to the issue again, Chair, in welcoming your ruling, hopefully that break will also get this thing sorted out as to who's going to call her first and so on. We probably would not have been able to resolve it today. But
I actually wanted to be clarified today, so
yes,
that we
no,
know
that's,
as we leave here,
we know,
who's leading,
so that we don't come back. No, no, I appreciate that. We don't come back and then be caught up in technicalities. I'm also raising it in that spirit. Now, Chair, the issue is this. At least I can taking everyone's bona fides on board, I can understand how this confusion has arisen. And I will refrain from using the word hijack. I think what happened is that, as I said in the morning earlier, we requisitioned the witness. You adopted the witness as the committee, in the sense that you, and then changed the scope in the process. At least that was our reading of it. Whether it's correct or not is another matter. Then the witness, unfortunately, caused even more confusion, because you said in one of your letters, Chair, you said to her that she must approach the evidence leaders for assistance. So it's either the witness or you who caused the confusion. You said in your letter dated 9th February 2023, you said, should you require the assistance of the evidence leaders to prepare a statement, kindly contact the committee secretary, Mr. Temigo Singoma, by no later than close of business on the 13th, and so on and so on. The evidence leaders are understandably exceptionally busy at this time, and the assistance is subject to you availing yourself. And okay. So again, that's why I'm saying, let's assume everyone was acting in good faith here. So I think then what then happens is that the witness, because of that, of what you said, then elected or accepted that she will be assisted by the evidence leaders. So when we wrote to her, still thinking she's our witness, to say, come and consult with us, she said, no, I want to consult with the evidence leaders. So that's where there was that hachi-pachi about who's going to consult with her. Fine. Ultimately, she did not consult with the evidence leaders, neither did she consult with us. She chose to have an independent statement. And I think this is a result of that. I'm not, without apportioning blame to anyone, because one of the results of that, Chair, is that that's why we have this mess now of the statements. Because quite frankly, whether it was the evidence leaders or us, we are professionally trained. We do these things every day. So the statement would have been done properly, either by us or by them. At least as you know that you've heard our statements from both sides. Yeah. So she deprived herself of that opportunity. And that's why we then had the delays and the statement coming on a Saturday and so on. But again, I'm assuming she was also legally advised and acting in good faith. But all that has now landed us in this, in the mess that we're in, where quite frankly, there's no statement before this committee, because this one is not a proper statement. It's not an affidavit properly defined, but I don't want to get into technical legalities here. So again, I'm hoping that will be sorted out amicably between us as colleagues and her, and find a way out of that little hole. That's done. The third issue, Chair, which I want to address is the issue of when then does she come back? Okay, Monday and Tuesday, which you are suggesting, I think we have a problem with Tuesday. We could do Monday. Because again, those were not sitting days. But the most important thing, even if we manage to make a plan, and we'll talk to you offline if we do, about the Tuesday thing, certainly the issue of the PP statement, because the real reason why we were so nice and accommodating about this week to pack it the way it was packed is that we needed the time to do the public protector statement, obviously incorporating the evidence that would have come from Ms. Mviana, Mr. Matabucha, and the public protector. I can tell you now, it's going to be physically impossible to do all that in 2 days, like on the Wednesday, in 1 day actually, which is yeah. So unfortunately, I know you like your program, but I think and again, we don't have to have that discussion here. We're going to need to find some way of accommodating that. Sorry. Yes. So that's the practical difficulty. There was even talk of doing it over the weekend. And maybe we'll have that discussion with the evidence leaders and see which weekend would be suitable, if assuming again that it will only take two days. Well, I'm assuming that the 2 days will remain intact. As far as Mr. Matabucha is concerned, yeah, it's a slight challenge, Chair. And in all fairness, much as we want to assist the committee, but really, I think there must be a realization that we're also human. And we can't be made to work like this. We suggested to you kindly yesterday, we wrote a letter and said, can we please have Mr. Matabuche today and tomorrow? You rejected that and insulted us in the process and accused us of wanting to make a delay when we actually wanted to bring him forward. As a result of that, we obviously then stopped our preparations for Mr. Matabuche, because even that suggestion to do him the following day was a major sacrifice on our part, because we were going to have to now work overnight to prepare for him. We didn't do that because you rejected our proposal. Now we come here and now you want to tell us at 11:45 that we must do Mr. Matabuche at 1 in an hour's time. That's just, I don't know what to even call it here. So I understand where you're coming from. You're also trying to accommodate us because you said we might need extra time for Mr. Matabuche. That I appreciate. But to do it like this is a bit insensitive. But having said that,
Yeah, if you can try and wrap up.
yes, thank you, Chair. Yeah, so that we don't actually get to 1 o'clock. Yeah. Having said that, Chair, I'm going to consult with my team and see if we can do anything with Mr. Matabuche today. Even if it means finishing him later on or whatever, but we cannot he cannot be imposed on us. I think we can be requested to try and accommodate him, and we will, given the fact that we would have been busy with him now if we had been listened to yesterday. Yeah, so the 6th and 7th is a problem. The PP statement obviously gets affected, and the Mr. Matabuche issue, Chair, I'm leaving it back in your hands, but I'm afraid it's not, I don't think it's something you can impose on us. We will try and accommodate where we can. But
just finally indicate you're leading Professor Madonsela, or you?
Oh yes, sorry. Yeah, that's the real issue you wanted to know. No, we're not. She can remain where she says that she preferred to deal with the evidence leaders, so they can have her. And yesterday the members claimed that she was the committee witness. You can also, the members' wishes can also be realized.
Okay, you've answered my question.
Yeah.
Thank you, Alfred Mpofu.
Thank you.
Maybe just before I give to members, just to clarify and correct 2 things. I summarized yesterday's discussions of the committee, and Ms. Madonsela, being the witness of the committee, was not part of that summary. So I really don't know where that came from. Secondly, you did make the point that you were excluded. You were not excluded. I indicated that the committee was having its own discussion, and that people were free to join with YouTube, but and whatever channel, but it was a committee meeting for the members to discuss their own in-house issues, and nobody else in that process who's not a member would participate. I thought I must clarify that, so that there's no exclusion from our side. Honorable members, okay, Ms. Ibrahim.
Sorry, Chair, if you'll just allow me to give some clarity on the question that I raised with Professor Madonsela before members come in, so perhaps that we don't waste time on that. There was an issue that the affidavit that was dated yesterday, as Advocate Mpofu said, stated Stellenbosch as the place of signature, but then stated that the Commissioner of Oath is based in North Riding, which is in Gauteng, as I understand it. I've now clarified with Prof. Madonsela that in fact she was with the Commissioner of Oaths yesterday in his presence and had it signed. This is his business address. Chair, I've just checked the regulations to the Justices of the Peace and Commissioners of Oaths Act, and it says below the deponent's signature or mark, the Commissioner of Oaths shall certify that the deponent has acknowledged that he knows and understands the content of the declaration, and he shall state the manner, place, and date of taking the declaration, and then there must be the full name and business address below. And she's now confirmed that that address is the business address. So I hope that clarifies that confusion.
Okay, yeah.
No.
Advocate Bauer, you had your hand up.
Yeah, I think the issue with the evidence leaders and Professor Madonsela, we do need to clear up. We had initially been asked to assist with Professor Madonsela's statement. We then had a backroom meeting on the 10th, which is the day after the letter had gone off. Certainly as the evidence leading team, and I haven't listened to the recording at all, we had left that meeting on at least on our part, under understanding that Professor Madonsela was the PP's witness. We assisted them in providing the contact details in order for them to make contact with Professor Madonsela for purposes of arranging a consultation. That was after that letter went out, after which we had sought to undertake. And that is why, although we had scheduled a meeting with Professor Madonsela for the following week, we stepped back to avoid any accusations or inferences that we were now seeking to interfere with the evidence of a PP witness. It wasn't that, no, that was our view of why we didn't.
Please don't respond to him. Yeah.
Now, Advocate Mpofu, I don't do this when you have the mic. You can at least have the courtesy to not interject.
I'll just apologize.
Are you
If
doing
want
it
me
again?
to, what do you want me to do now?
I've not recognized you, Advocate Mpofu.
Thank
Go
you,
ahead.
Sorry, Chair.
So certainly from the evidence leader side, we had certainly not contemplated that Professor Madonsela was a witness which we had brought to the committee. For two specific reasons. The committee had entertained having Professor Madonsela as a witness at the behest of the PP's team. We had previously, when we did our inquiries before the committee commenced in May and June, met with Professor Madonsela and made our assessment as to whether she was a witness whose evidence would be of assistance to this committee in determining the issues on the motion, and on the basis of evaluating what other witnesses we had, we decided that she was not, that what we needed to ascertain from her in relation to Vrede and CX, we could get from witnesses who were being called in respect of that and other matters. And we certainly didn't take the view that when we needed to put evidence before the committee, we needed more than one person to say the same thing. That is a waste of time and it defeats the purpose. So that was where we came from as the evidence leading team. If the committee had said to us, this is a witness that we wanted to hear from, then certainly we would have gone out and done that. But it was on the basis of our interaction in the back room where it was made clear to us that we wanted to do that. The decision whether she wanted to consult with the PP's team and whether she wanted them to do her statement, that is the witness's choice in election. I was never told by the chairperson or by the committee that this was somebody we really wanted to hear from and you should go out and do the statement. When a name has come up in the committee, for example, over and above the list that we have put up, we've either explained why we haven't called the person or we've endeavored to see whether there was any relevance to the motion. Now that is an important fact because as evidence leaders where we stand now, I'm still not convinced of the relevance of Professor Madonsela's evidence to this inquiry, even based on the statement. So there must be some clarity because if you're going to say that to us, then I'm going to say to the committee, well, I don't see any reason why I should be called for oral evidence at all. Sorry, Chair, on the second point, there was an arrangement made with us and the PP's team in respect of the PP's written statement. We had worked out the schedule that the proceedings would be done by Thursday. We a day later on it, and that the statement would would be provided by next Wednesday, in order for them to then have had the Friday, the Monday, and the Tuesday for purposes of finalizing the statement. The statement was then going to come on the 7th for the PP to commence evidence on the 15th, on the understanding that Advocate Mpofu would take a day of next week to prepare for his hearings on the 13th. So I am taken aback, given that the understanding was that they would be busy with the PP statement on the 6th and the 7th for purposes of submitting that to the committee on the 7th, that the PP's team is now unavailable for a hearing on the 7th.
Chair.
Okay, I think on the committee will deliberate on this issue of who leads or who cross. It should not be a difficult thing to. I would not want it to be a to and fro thing. We will.
Okay, Chair.
We'll make that decision. That's okay. Go
Thank you,
ahead.
Chair. Thank you, Chair. Sorry, I'm sorry to. I don't intend to waste your time. Well, apart from the unfortunate remark that is made towards the end. Firstly, I never said the PP's team was not available. I said we have a problem on the 7th because one of our, or some of, anyway, I don't have to get into details, but I didn't say what is alleged I had said. But even if I had said it, the point I'm making, which I hope will not perplex Advocate Power very much, is the fact that even assuming, and I said I was going to make a plan, so I don't know why she's going on about that. But I was saying, even assuming we do that, we would then be left with 1 day within which to make the statement, which is just completely unreasonable, even to the perplexed evidence leaders. The issue, Chair, is that, you know, I don't know, it's unfortunate that we have to do this like this. The Advocate Power tells us that she doesn't even think of Advocate Madonsela has any relevance. The first time Advocate Madonsela appeared on any witness list was on Advocate Power's witness list, which they give to us in July. And I don't know why she was relevant in July last year and appeared on their list, and now suddenly she has become irrelevant. So it's just completely disingenuous to now want to backpedal on that point. So that's the first thing. The second thing, it is not true that because of our meeting on the 10th, that negated your letter on the 9th, Chairperson. Because the letter on the 9th, you said the witness must contact the evidence leaders, presumably on some understanding with them. Advocate Power is quite correct that in the meeting of the 10th, we willingly said, we are the people who have called her, and therefore we will assume responsibility for her, like we did with Ms. Mviana, like we would do with any other witness that we have subpoenaed. I don't want to repeat what I've already said. What then followed is the fact that the witness herself wanted to consult, probably either following your letter or of her own accord, and I don't want to speculate what was going on in her head. But she wanted to consult with them. She wrote to us on the 20th of February, 10 days after the meeting that Advocate Power is talking about, and said, regarding my willingness to prepare a statement for the committee, I'm willing to do so, and as indicated to the committee, prefer to do so independently. That's the first thing. It is my understanding that witnesses at an inquiry, like witnesses in the public protector investigation, sought to help to locate the truth, wherever it may be hiding, she says at her paragraph 5, and not embedded with any party. That's what she says. The tradition, as I understand it, is that the evidence leaders assist with preparation of statements, which I presume, among other things, ensures relevance and admissibility of evidence. She said, having been advised that your team has forbidden evidence leaders from assisting me with my statement, I've decided to prepare the same on my own. I've explained that we told her that that's false. We never forbade. She apologized. That's water under the bridge. So let's put that aside. But we cannot detract from the fact that 10 days after what Advocate Bauer is telling us, the witness said she preferred to consult with them or to go independent. Ultimately, she went quote unquote independent with the results that we now know. And then she said at paragraph 8, Chair, kindly note that from the committee's side, this is where you come in. It appears that I only needed to share what I know on the CX investigation, spelled SIEX, investigation. This is where we told her that it's not spelled as SICX, it's spelled as CIEX, and there's also Frede on top of it. I've already given you that history. So it was this letter of the 20th, which is only last week, that this issue arose. We then wrote back to her and say, okay, if you want to go independent, fine. But please be reminded that there's a 7-day rule. I've already told you what happened next year. So let's just be factual and correct and
Okay.
and not
Thank you.
change.
Thank you. Honorable members.
I have a point of correction that I think is important to understand in the context of what the evidence leaders had provided, as far as the witness list is concerned. I think it's correct to say that the evidence leaders provided the witness list on the 1st of July, on which Professor Madonsela's name appeared together with 28 other names, not all of which was called. The preface to the witness list was stated as following: this list is currently confidential and is only being provided to the legal representatives of Advocate Mkhwebane. The evidence leaders seek to keep the identity of witnesses confidential until such time as the evidence is provided to the committee. If the evidence leaders determine that the written or oral testimony of a particular witness is not required for the proper assessment of the motion, they may decide to not call such person unless otherwise directed by the committee to do so. The above witnesses may either be called to provide written or oral evidence or a combination of both. The names of the list appear, and that's it. The rest is not relevant. So I think the presence of Professor Madonsela's name on the evidence leaders witness list was qualified.
Honorable members, your take on, I've placed some issues here. You've had the responses, counter responses. If I may hear your voices on the matters. Honorable Nkosi, you will start. Any other member? Mylam. Honorable Tlakude. Mwaneli, thank you. Those would be the 4 names. Honorable Nkosi.
Thank you, Chairperson, and is it still morning? Good morning. Afternoon. Firstly, Chair, let me apologize. I have a meeting that is starting at 12. I had forwarded the apology earlier, so I will not be able to sit through. Okay. But on the issue, I think it's clear that we facing a dilemma we faced when we decided to issue the subpoena on relevance and on what issues. Remember that we were persuaded to issue the subpoena because of the belief that her evidence was going to be relevant to the issues, particularly on CIX and whatever. And then we agreed to confine that to those issues. But from what we hear now from both sides, it's clear that nobody thinks that she is relevant. Her evidence is relevant. And I'm prepared as the committee to say, no, look, we can take a decision not to take her because nobody wants to lead evidence. It's not relevant. If the evidence leader says she's not relevant, they don't want to take her, then we don't need that evidence. We said so. We also said at the time that it's important that when you come to this witness, all issues related to her evidence should be resolved and sorted out before we even appear here. But we're back at that. So my view, Chair, is that I agree with your summary and how you want her to appear. If the issue of the relevance of her evidence, including the statements and clarifications of the statement, is not resolved either way, then we do not have to call Advocate Madonsela. If it is resolved, yes, true, we will call her and then she'll come and present. But if really this issue is not resolved on who or on whose behalf she does so, then I'm prepared as a committee to say, look, in any way, we didn't want to subpoena him. May I leave, Chair? I'm not disrespecting you.
Thank you, Honorable Bekizo Ngosi. Honorable Mailam.
Thank you, Chairperson. And Chairperson, let me apologize for not putting on my screen. My Wi-Fi is a little bit dodgy today. Chairperson, I just want to address one issue, and that is the fact that it was at the request of Advocate Mkhobane's legal team that Professor Madonsela was subpoenaed. To put the burden on the evidence leaders to now lead that evidence is frankly, in my opinion, unfair, because they have not said or have not identified any evidence that they wish to lead. The person or people who wanted to call Professor Madonsela were the public protector's legal team. So the burden should be on the public protector's legal team to lead that evidence and then allow Advocate Bauer to then cross-examine. That's my opinion. Thank you, Chair.
Thank you, Honorable Mailam. Honorable Tlagode.
Thank you very much, Honorable Chairperson. Morning, evidence leaders, the PP's legal team, and Professor Madonsela on the virtual platform. Oh, it's a good day. Honorable Chair, I want to fully agree with my colleagues. Yes. Professor Madonsela was subpoenaed because the PP's legal team wanted her to be subpoenaed to appear before the committee. So now, because no one wants her to come, I mean, the evidence leaders and the PP's legal team, they don't want her. So as a committee, I want to suggest that we adopt her, that Professor Madonsela come and address us as a committee so that we can see what we'll get out of that. No one wants her, we want her, because we want to understand the subpoena and now no one is owning her. So if Advocate Professor Madonsela is available, then we will have her so that we can have clarity, we can get clarity on those issues that they wanted her to come and clarify. The CX matter, the Friede dairy farm, we are interested to hear that. Then with regard to the statement, I think Ms. Ibrahim said that the statement doesn't change the content. It's only the cosmetics of it, which I understand can be corrected because she said the statement doesn't change the content. So it's fine. They must correct that and we move forward. Then with regard to Mr. Mataboge appearing before the committee, we discussed this matter yesterday. that we will have Mr. Mataboge on Friday. Our understanding as a committee is that you don't prepare ngesintu sithi ngema last minutes. We would have expected that the legal team would be ready,
You can look through the chair.
Yes,
So that you
would be
don't.
ready
Mm.
with the witness. So that is our take. Maybe I took it for granted that they are overworked or not, but that is how we do things, Tina, in Parliament. That you know that you have 3 meetings tomorrow. After the last meeting, you go home, refresh yourself, and start preparing for those 3 meetings that you are going to have. So that is our expectation as a committee, that so they'll respond for themselves. You will respond when you are given a chance. Then we accept your summary, Honorable Chair, that the statement of the PP will have it on the 9th. Then that is acceptable. Thank you very much, Chair.
Thank you, Honorable Labode. Honorable Maneli.
No, thank you, Honorable Chair. Greetings to members, the PP legal team, and Prof. Madonsela on the platform. Chair, I want to start by agreeing with, firstly, the summary you made yesterday, which you've clarified again, that's still correct. The second point, it's on what you've made as, again, the summary of the discussions of the break and how you're guiding the committee going forward, including the request for us as members to still be prepared to hear the other witness, which the PP's team, as they correctly said, they would have asked for that, Mr. Mataboge to come even earlier as part of assisting the process until this discussion we had yesterday. And I want, as I say that, Chair, to indicate that we are discussing because we needed to consider that that is put before us. And that break was necessary because we were entertaining what is before us. And that allows us then to review the positions we may have had, like that of continuing with the witness to be sworn in. And I'm using that wording, the witness to be sworn in, that we're unable to proceed in that regard. So it means we would have listened, so changing the view in that score. And therefore, there's no problem in looking at the issue of Mr. Mataboge on availability and going forward with that, not just on the basis of time, Chair, that's being chased, but as I say, on the basis of looking at whatever is presented before the committee and applying the mind on that. Now, coming to the point of the witness to be sworn in, Chair, it's unless I didn't understand it. The first thing is that the committee has not come with this witness. We discussed the matter at the request of the PP's side. And that discussion was meant to assist them to be able to proceed. As I say, Chair, it's unless I didn't hear the PP's side from the legal team has now made it clear in answering you to a question you've posed that they are not having that witness anymore. It's the witness that the evidence leaders or the committee, as it discussed yesterday, those were the references made, that it's with the committee. And I'm saying that being the case, Honorable Nkosi then is correct, because we've never considered it to be a witness. That witness was not considered by the committee. The committee would elect to take the statement that gets received. On the basis of that has been received, you conclude then that there would be no reason really to call this witness, as those that requested to have that witness would no longer be interested in having that witness, because if they are interested, it will be their witness and therefore would lead evidence in that regard. So in this case, we don't have that witness. And I would say, Chair, it's also not about the time. It's about matters as they are presented before us. Probably the issue about time would be that in the absence of that witness coming on Monday and Tuesday, it is only extra days for preparation on the other side, so that you are able to get the statement. I'm saying this without taking away the extra 2 days you said that gave up until the 9th, so that there is preparation in that regard, Chair. So I just thought I should agree with Honorable Nkosi, so that it's not like we wanted the witness. The committee only discussed because there was a request on the table. Thank you.
Thank you, Honorable Maneli. Honorable Walangwala, I think you are the last one. That's the last hand I have. I've not seen any other hand. Oh, Sukas. Honorable Ngola, over to you.
Thank you very much, Chairperson. Chair, this is not the first time we are discussing the relevance of the evidence of Advocate Madonsela. If one would recall, Chair, after having received the letter from Advocate Madonsela saying she does not believe that her evidence will actually be relevant to the work of the inquiry, the committee has made a discussion around this matter on the relevance actually of the evidence to be adduced by Advocate Madonsela. And Chair, in that discussion of the committee, we agreed that not only is the affidavit ought to be deposed by Advocate Madonsela, we qualify as the only evidence. We have said, Chair, we shall remember that since the resumption of this inquiry, we have had witnesses making serious allegations of altering of information in reports, particularly in respect of the Fred Daily Farm and the CIX report. So that forms part of the basis at which we have said Advocate Madonsela still remains relevant to the work of this committee. Now, we have said we're going to, as the committee, find thematic areas where we think she will be able to assist the work of the committee, which in the main was Fred and CIX. Now, the affidavit she deposed speaks unto those particular reports. I doubt, Chair, from where I'm sitting, that her relevance has now diminished. We see that there is evidence leaders, the legal team of the Power Protector know that witness is theirs, no, is us, and all those things. But I think Honorable Jakude is assisting us going forward. In that, if there is this dilemma, we as the committee remain with a conviction that the evidence of Advocate Madonsela still remains relevant. And therefore, we still are willing to hear the evidence from Advocate Madonsela. Now, we're taking a decision as the committee that we're taking her as the committee witness. It's a suggestion. that I want to agree with Honorable Lagude, but let's take Advocate Madonsela as a committee witness. Then if Advocate Madonsela is a committee witness, that therefore means the evidence leaders are supposed to prepare the witness on behalf of the committee. Now, Chair, if we check the program that was adopted by the committee, we're supposed to have the last day, Friday, then resume on the 15th of March. So if the chair, the secretariat, the evidence leaders, and the legal team of the public protector can do the backroom arrangement and find a suitable date in between Friday and the 15th of March, where whether they find one day or two, where Advocate Madonsela must appear before the committee. I'm saying this, Chair, because the allegations that were made against Advocate Busisiwe Mkhwebane of having altered evidentiary material in these particularly two reports was done in the public discourse in this committee. So we need that kind of information, whether to confirm those allegations or to rebut those allegations. So I want to propose, Chair, that we follow the proposal by Honorable Lagude that we must have Advocate Madonsela. If indeed we've got various convictions as committee members, the neutral ground we can reach is not to dismiss evidence, but rather say we receive we'll take the evidence as a written statement, as we did to Advocate Malunga. But that must be the neutral ground, Chair, only if this proposal that was made by Honorable Lagude does not see the light of day. Thank you very much, Chair.
Thank you, Honorable Ngwala, and your neutral grounds. Honorable Sukas.
Yeah, Chair. Good morning, Chair. Good morning to the committee. I share a different view, and I'm in support of what was said by Honorable Maneli as well as by Honorable Nkosi. The context is important because the context was that the previous public protector was going to come and testify or bring evidence, or was needed to bring evidence because the request was coming from the PP legal team. Now we have this situation where first we had the request for the witnesses to be changed for today and for tomorrow. And it is my view, Chair, that as a committee, we discussed on Advocate Madonsela only because the request was that she needs to appear here as a witness. So I just want to support that view that if the witness is no longer owned or needed by the public protector's legal team, then as a committee, we proceed with the next witnesses that is before us. I think it is time is important. I have a total different view. I think time is important. Time is having an impact on the work of the committee in such that if you have members that has responsibilities as well, we need to understand the impact, not only on the witnesses, but on the committee as well. So within that context, it is important, I think. You cannot take time out of the equation, because with time comes cost, and with time comes as well the onus that's on the committee to, within a reasonable time frame, complete this process, Chair. Thank you.
Thank you, Honorable Sukas. Yeah. You'll be the very last, Honorable Gonde. And we'll try and summarize.
Thank you very much, Chair. I wasn't going to say anything, but you know how the adage goes, speak or forever hold your peace, and I don't want to hold my peace, so let me speak. Chair, I was going to support Honorable Sukas and Honorable Maneli. I do agree that if Advocate Madonsela now finds herself motherless or an orphan, as you indicated, then we should definitely then do away with her, with having her as a witness. I agree that at the time, the public protector's team had indicated that she would add value to the inquiry. And Chair, I would like to remind us as a committee that, the purpose of this inquiry is to gather as many, facts as we can in order to be able to, make a recommendation to the National Assembly. So I tend to agree that if we are finding ourselves in this situation for the sake of time and the sake of expediency, that we should actually do away with her as having her as a witness, and then dispense with Mr. Mataboge because, he's almost halfway done. And then we get the public protector because I think she is the subject matter of this inquiry. And we really need to hear from her. And I'm sure she is, also looking forward to, giving evidence to this committee and having her side of the story, related and ventilated. So, Chair, for the sake of time, which is not on our side, I would agree with Honorable Sukas and Maneli that we please proceed and move on, because I find that we are constantly getting bogged down with issues that, we really, which really do not constitute, the subject matter of this inquiry. And it's one issue after another, and they're getting really exhausted, and we're moving away from the bigger picture here, which is trying to, to do the work that we have to do as the inquiry. Yeah, I think that's it from my end. Thank you, Chair.
Sure.
Thank you, Honorable Lagude. Honorable Gondo. Honorable Lagude, I see your hand, and then Honorable Olomisa.
Thank you very much, Honorable Chairperson. Listening to my colleagues and the majority view, I want to retract my statement. Thank you.
Okay, thank you, Honorable Lagude. Honorable Olomisa.
Thank you, Chairperson, colleagues, and everybody else who is on the platform. And I was raising my hand to support the proposal by the Chief Whip of the majority, the Deputy Chief Whip of the majority, Mahmoud Lagude, but I hear now that she is withdrawing. Notwithstanding that withdrawal by her, I fully agree with her earlier position that we need to allow the committee to invite the public protector, the former public protector, Prof. Madonsela, and then the evidence leaders, as well as the legal representative of the public protector, would still be free to pose any question. I don't know what is the problem here. Unfortunately, there is a legitimate expectation on the part of the public, since the name of Prof. Madonsela and the controversies around her statements and whether she will participate. I think it would be fair for this process that the committee should invite her and clarify whatever we want to clarify. So for us to say no, we don't want to be associated with that kind of drama. Thank you.
Chair.
Thank you, Honorable Olomisa. I think I've listened to all the members. It's my duty to summarize what I think I'm hearing them saying. I don't know what that hand is.
It's a small hand.
Advocate Mbofu, because
It's a finger.
you're not one of the members, so I need to summarize what they are saying.
Okay.
So
No,
so if you want to come in,
okay,
please come in.
I do.
Before I do that.
Yes, please, Chair. Hopefully before you summarize. Yeah. No, Chair. Really, you know, I don't know whether it's deliberate or not that people just want to torture us emotionally today. Chairperson, I've said that, you know, the public protector is a human being, and she is owed the least that you owe her, all of you, is fairness and consideration, as much as you would want to if you were facing impeachment, dismissal from office, whatever, you know, or if it was one of your relatives or someone you know. That's all. We don't ask for anything more than that. But this kind of cruelty and vitriol is just unpalatable. The public protector has never said that she does not seek the evidence of Advocate Madonsela. In fact, she has said the opposite. I read it out to you this morning. When Advocate Madonsela thought her evidence was only confined to CX, we pointed out to her, for which she was grateful, that no, the committee has raised two issues, CX and Frede. And I agree with Mr. Ngola, much as I don't like to agree with him often. But he's 100% correct. Those were the two issues that were identified by the committee. Advocate Madonsela, because we wanted to consult with her, not because we did not want her. We said, please, we want to consult with you. She says to us, what are other extra issues that we need to put on top of the one or two that the committee? Then we respond by giving a list of the 8 other issues, including the issue that Honorable Ngola, again, I don't know why I'm agreeing so much with him today. This is what Honorable Ngola said to Mr. Siabi. That's one of the issues we listed there. When the old man was sitting there, 8 years old, crying tears and explaining what he had gone through. And this is what Honorable Ngola said to him at the end, to try and pacify him as a member of the public, to which hopefully we're all accountable. And I quote Honorable Ngola. He says, lastly, Chair, Mr. Siabi raises some issues on paragraph 22 of his affidavit, in respect of which why there was no consequences suffered by Mr. Samuel for the deeds that he did against his person. The only thing I would say, Chair, is that in that regard, is that Advocate Madonsela is due to come and appear before this committee. We surely will ask that question on your behalf. We hope that you'll be watching for you to get other answers in respect of that particular specific matter that you raise in paragraph 22, says Honorable Ngola of this committee to Mr. Siabi. We raise that with Advocate Madonsela to say, apart from Frede and CX, there are issues such as these, where people have accused you of the most horrific things and the most horrific behavior. You need to have your chance to clarify. Maybe she might say, I've never even heard of Mr. Siabi, or it was not me, or whatever it is. So raise those issues. But now people are saying, by saying that, we mean we don't want to speak to Advocate Madonsela. When we were the ones who brought those witnesses here, Mr. Nyatela went on the whole day about what he perceived to be emotional torture at the hands of Advocate Madonsela for delaying his matter for 11 years or whatever he alleged. And it's only fair that Advocate Madonsela should be given an opportunity to deal with those issues, even if it's just to deny them. And so anybody who really is so heartless to think that by raising all those issues, all it means is that, oh, well, then more than that, we begged Advocate Madonsela last week only to say, please, we want to consult with you so that we can raise those issues. She elected, as she's entitled to, as any South African, that she would rather talk to the evidence leaders or her own lawyers. That's fine. But that does not take away the rights of the public protector to raise these issues. So, Chair, to assist you, maybe this is what should happen. It's either we Advocate Madonsela is asked if to consult with us so that we raise these issues, and then we present a statement. If she is averse to that, then she can consult with the evidence leaders and they can prepare a statement on behalf of the committee or whatever. And the rules are clear as to what should happen in either one of those. We don't care whether we're going to lead the evidence, but for anybody not to understand, we can't lead somebody on a statement that's prepared by somebody else. It doesn't happen. If we take her statement, then obviously we will lead her. Leading evidence means examination in chief. That means you already know what that witness is going to say because you are the one who consulted with that witness. You are the one who prepared their statement. And that is why when Mr. Mataboge, also exercising his rights, chose not to make a statement, he was then told, fine, there's nothing we can do. We can't put a gun on his head to make a statement. And he was called here. He was led by the evidence leaders. We are now at a point where we are about to cross-examine him. It's a very, very simple issue, which is catered for by the rules. But this notion of saying that, you know, let's throw the baby with the bathwater, or as the cruel King Solomon said, let's cut the baby into half so that we can see who the real mother is. It's just, you know, unbecoming of a body like this.
Thank you.
Sorry, Chair, just 1 second. Let me just check my notes so that I don't bother you again. So the notion that she's no longer needed must be rejected. It's a question of, and I had suggested that we go to the back room and talk to the chair and engage and so on and find the most practical way of doing this.
Okay. I'm still on.
Chair, I'm sorry.
Please wrap up.
I know, Chair. Yeah. No, okay, no, it's fine. I think, yeah, it's all right. I don't even think I need to address the issue of what Honorable Tlakuda is saying, of thinking that we should, you know, if there are 3 meetings, you prepare for all 3 meetings. When the committee cancelled the meeting yesterday, which we had asked for. So I don't know if you prepare for meetings that have been cancelled. We asked for the witness to be brought today, and you decided not to. So how would we prepare for that? Now, the Chair, sorry, there is just a small, yes. My constructive proposal, Chair, is the following: that we, after you summarize the position, we'll leave this issue because it should not be resolved like this in the public domain. We'll leave it as to how and when Professor Madonsela should be brought to assist the process, the committee, by whoever will lead her. And then, because this is now 25-1, Chair, we would request, and I would like you to incorporate that maybe in your summary, would request that if you are still interested in not wasting the time and maybe having Mr. Mataboge, that we have that in the morning so that we have an opportunity to go and prepare, because we had come here having prepared for something completely different. So that's that's our constructive proposal on both issues, Chair.
Thank you. Ms. Ibrahim, I want to summarize the members' discussion. Please switch off your mic, Advocate Bauer. Ms. Ibrahim?
Chair, I just wanted to place something on the record for clarity. Mr. Mataboge is a distinguishable witness. He was not requested by the public protector. He was not part of the list of people that they wish to summons. The committee, having regard to Ms. Bianca Mvuyana's reasons for not wanting to come to the committee voluntarily, then made a decision to call her. And that is how it then followed that the evidence leaders led Mr. Mataboge. This is distinguishable in that the public protector has requested that Professor Madonsela appear because they have a list of questions which they wish to put to her. So if I can just please have that on the record. Thank you.
Thank you, Ms. Ibrahim. Advocate Bauer?
Chair,
Advocate Bauer?
sorry, Chair, maybe before you come in.
Advocate Bauer?
Oh, okay, sorry, Chair. But please then recognize me. I want to correct.
Yeah,
that.
I do feel it important to remind the committee and maybe to coin a phrase that Advocate Mpofu has used several times in the proceedings. This is not a motion to examine the behavior of Advocate Madonsela in any instance. So if any way she may have treated anybody, let's assume the worst case scenario that what was told to this committee is true. For purposes of the work of this committee, the question to be raised is so what?
Thank
Okay.
you, Advocate Bauer.
I'm happy with that.
Let me now summarize for the committee. I will start with the issue of Mr. Mataboge. Mr. Mataboge was scheduled for this committee, evidence leaders led, and at the point of the public protector legal team having to take over, they invoke the directives, which was accepted. And at the time, we would have planned for an allocated set of time for Mr. Mataboge. We receive the request that the public protector legal team would like to, because he's scheduled for Friday, for us to complete with him. In the to and fro, they would have requested that he come in today and tomorrow, basically requesting to add another day on the programs. So that has to be acceded to first. It's not just automatic that would do that. Well, if it's 2 days of Madonsela, it belongs to Madonsela, not Mr. Mataboge. And so I had made a ruling earlier that says, with Mr. Mataboge agreeing, with the public protector team being able to do that, we want to spend the rest of this afternoon and as well as tomorrow with Mr. Mataboge. I get, even though Advocate Mpofu said he will still speak to his team, that there's no readiness for today for Mr. Mataboge. Which therefore means we're left with tomorrow with Mr. Mataboge. I would have loved that would have given the public protector legal team tomorrow, as well as the rest of the time of today. But as indicated, they do not think that they will be ready to interact with Mr. Mataboge today. And therefore want to accede that we will continue with Mr. Mataboge tomorrow, and Mr. Mataboge will end tomorrow, whatever time we end. That's a time for Mr. Mataboge.
Yeah, Mr. Mataboge has a 5 o'clock restriction for person.
Okay, I know that's 5 o'clock, but at least that's we use the same. So the allocated time is fine. So which is what would have helped that you spend the rest of the hours we have today as well as tomorrow. So that's on Mr. Matabuche. And I'm saying Advocate Mpofu did indicate that he was going to speak to his team. But if that does not materialize, that we conclude Mr. Matabuche tomorrow, Thursday being the 2nd of March. On the next 2 points, in listening to the members on their discussion, I think firstly, the first issue that must be concluded is the cleaned up statement must be finalized, because there were corrections made to the statement to attend to all of the issues that can be tricky points, so that it's there's no questions around that statement, even though I agree it's cosmetic changes. So I'm sure by the time we close this meeting, that could be done, if it's not done now. With that statement cleaned up and done with all of those corrections and cosmetics, having listened to members, I had put the question to the public protector legal team. They have given me a clear response. I cannot doubt that. And on the basis of that, colleagues, to bring Honorable Ngola's points and Honorable Olomisa, as well as the rest of the other 5 members who had contributed to this issue. This is the ruling I make on the matter of Advocate Madonsela, who's been with us this morning, is still with us, and we appreciate that. That cleaned up statement would Honorable Ngola assist in your neutral ground that you have indicated, because we adopt that as a committee, that she responded to the 2 issues we asked her to respond in a written statement, Friede and CX. The statement speak to those issues as required, as decided by the committee, and that we take that as a committee as a written evidence, which is on record to this committee, and therefore it helps us therefore as a committee to do away with the proposed oral evidence of Monday and Tuesday, because we have that on record, so that we don't get into, I've addressed that enough, and I think that the members have accepted that the committee must adopt the witness Advocate Thulisile Nomkhosi Madonsela, and therefore that adoption with the cleaned up statement means we have on record her response to the issues that were required, and therefore we would not need to go any further with an oral evidence when she would have responded to those gray areas that we wanted her to respond to. So in that regard, that's how I want to conclude the matter on Advocate Madonsela before I thank her. Is there anybody with a grief from members on that? Maybe I'll start with Honorable Olomisa. Honorable Olomisa.
I raise my hand to completely disagree with your approach, because if one of the members of the committee during the discussion wants to ask questions, are we going to write another question, put another question in writing to her to clarify? Why are you hiding her not to come and and answer questions verbally. And just rule out of the blue.
Thank you, Honorable Misa. Your objection is noted. Any other member? None. Thank you. And that is now going to be the decision of the committee, noting the objection of Honorable Holomisa. I want to move now from this point. Perhaps you raising your hand, Advocate Mpofu, and then I'll go to Ms. Ibrahim.
Right. No, Chair, I just want to say this, that I don't know why these members of this committee are complicating the work of this committee and making it more difficult for us to proceed with the inquiry, because the things that you're doing in the last 48 hours really are just, I don't know whether it's a plan to try and sabotage the committee, because you know that it's not going to end well, this approach of just bulldozing. Firstly, I just want to make a factual correction. Ms. Ibrahim is wrong, because we gave you a list of witnesses, and it was like this. Okay, I won't read out the people who have not appeared here. So it says, latest, after you insisted, Chair, that we give you a list. Latest list of witnesses, confidential and not for external dissemination, as at 8 November 2022. Number one was number one. Number two was Honorable Zulu Sakoni. Number three was Mr. Rodney Matabuche. Number four was Bianca Mviane. Number four was number four. Number five was number five. Number six was Advocate Mkwebane. Then Lamola, Freddie Nyatela, and so on. Then those to be approached, Godan, Madonsela, Mazoni. And then still being traced, Mr. Peter Siabi. That was the list that we sent to you and the committee per your request. So that distinction between Mr. Matabuche and Ms. Mviane is not, and Mr. Madonsela, Ms. Madonsela, Advocate Madonsela, Professor, is not true. So it's all very well to do things here for convenience, but they're not going to withstand proper scrutiny when the crunch comes, because you just want to run roughshod when the facts are now put. And that's why I brought these letters, to read them to you so that you make your decisions on an informed basis, not an emotional or vindictive basis. So that's the issue. So the comparison I was making with Mr. Matabuche is completely valid. Secondly, Chair, you can't, on the basis of this statement or affidavit, well, I don't even want to call it an affidavit, which does not even address the issues that Honorable Ngola is talking about whether there was a change of or a manipulation of dates or whatever by Advocate Mkwebane. Even forget about all the other issues, just on Friday and CX. It doesn't deal with those issues at all. It doesn't deal with the issues raised by Mr. Samuel about what Advocate Madonsela said to him, about when the file was being transferred to the Free State. A whole host of issues. I don't want to bore you with the list, but it doesn't even scratch the surface, that statement, on the issues, just on CX and Friday, forget anything else. So for you to come and say those issues are addressed in the statement, it's just not true. You might as well throw it into the dustbin because it doesn't deal with those issues at all. Now, let alone the issues that Honorable Mola said would be dealt with the statement, but I'm happy to hear what the evidence leaders are saying about that issue. And I want, even if she comes, I won't ask any questions to do with that, because according to them, we must then just accept the evidence of Mr. Nyatela and Mr. Siabi, because even if it is so what? Great. So that we will deal with in the implications of that concession will be dealt with when we do the argument. But for our part, we require the evidence of this witness. The evidence of this witness is clearly relevant. And if there's now going to be a somersault on calling her, then it will be a matter that will have to be resolved in another forum, because now we're just being bullied into a situation or depriving us and the committee, or well, at least the public protector. The committee, if it doesn't want to know the truth, that's fine. But the public protector is denied her right to call a witness and question her about issues that are clearly relevant to this committee. So, Chair, as far as the other matter of Mr. Matabucha is concerned, this is, at least my team's view is this, that if the I had forgotten about his 5 o'clock restriction, because I had thought then if we were going to start with him, then we would just go on for as long as possible, so that or either today or tomorrow. So what we would propose, Chair, on him is that if we can even start, at least the suggestion from my team, that we can start with him at 3 o'clock, so that we do the one section at least of the 4 reports, and then hopefully maybe we start early tomorrow at 9, and see how far we go with the other 3 sections, given his 5 o'clock restriction. But on the I really wish you had just adopted our proposal, which we repeated many times, which was that the issue of Advocate Madonsela should be left to a discussion between yourself and the evidence leaders, and try and resolve it. I appeal for you to do that, because I think the alternative is not going to be very pleasant. So we need to get over with this, accommodate and be fair to both the committee members and the public, and Advocate Kwebane, and of course Advocate Madonsela herself, and try and find a solution that is not characterized by bully boy tactics, and one that is constructive, that is going to take us forward and accommodate the exigencies, so that we take into account the interests of fairness. And Advocate, or rather Dr. Gondwe, I think, has made a Freudian slip. She says we must do this for the sake of expediency. Well, if we are going to do things for the sake of expediency, then I think we all know where that will lead. I think she wanted to say expedition, but expediency is not going to get us far. Thank you.
Thank you. Advocate Mpofu, Mr. Brian.
Chair, just 2 quick things. The one is that the PP's legal team made it clear to the evidence leaders in a meeting in which I was present that they had no intention of calling Mr. Mataboge any longer. So notwithstanding that Mr. Mataboge was still on the witness list as submitted, the intention was clearly conveyed in much the same way that the evidence leaders over time have also conveyed their intention not to call certain persons who were on the original witness list. But anyway, be that as it may, Chair, the real issue that I want to attend to is the one regarding the statement by Professor Madonsela. The statement dated 28th of February already contains all of the changes that were made by hand now in an electronic format. So there is nothing further to be done. So I just wanted to clarify that we don't now need to go back to her to ask for anything over and above what we've already received. Thank you.
Thank you. Quickly on the issue of Mr. Mataboge, I was hoping that you would request 2, but you're requesting 3. That's fine. I will accede to that. And then we can also ask members to be flexible and then we'll start at 9 tomorrow, if that's okay with the members. So let me repeat it again. The request, which I think that is fair, was only raising an hour in it, but I won't go to war for that. The request was that we start at 3 this afternoon. We have extra 2 hours with Mr. Mataboge.
Chair, I'm sorry to interrupt you. I'm even prepared to compromise. We can make it 2:30. I needed 2 hours just to prepare to go and fetch my notes, and because I've left all those files in the hotel and all that. Yeah,
that's in order.
So
We'll start 2:30 with Mr. Mataboge, and we'll start at 9 tomorrow. Is that in order, members? And a earlier hour than 10. Honorable Dlakude.
Thank you very much, Chairperson. We fully agree. Thanks.
Okay, thank you. So that's it, members. Now it's about 1. Maybe let me take this opportunity to address Advocate Madonsela. If you can maybe switch on your camera.
I'm so sorry. Sorry, Prof.
Okay, just pause, Advocate.
Yes, no, Chair, I just wanted to say that sorry, I forgot to say that okay, well, it won't change the 2:30 thing. Maybe we'll send it for you overnight or for tomorrow. That if you go ahead with what it looks like you want to go ahead with now, then one of 2 things is going to happen, which is either to take that issue to court or to make a fresh application for you to summon the witness. And maybe that's what we need to do to exhaust, because we have to exhaust our remedies. We can't just, but that's something we're going to do, in which case you'll probably have even a much longer delay in your hands. But that's, I just wanted to say so that you don't overpromise anything to the witness. I think we're going to see her either soon or later. Thanks.
Well, I don't know about that anticipation. Firstly, you don't know what I was going to say with the witness.
No, and
let's just put that very clear.
I'm basing it on what you already said.
I didn't recognize you.
Oh, sorry.
Thank you.
I was not addressing what you're going to say. It's what you said already. Thank you, Chair.
Thank you. Advocate Tulisile Nomkhosi. I hope I'm doing it right, because there was a Nomkhoso thing and so on. Nomkhosi Madonsela. I want to, as a chair, firstly, profusely apologize that we had you here since 10 o'clock as scheduled and directed by the committee. It is now 1 o'clock. You've been patiently sitting there and waiting for the opportunity for you to present to this committee your testimony. We have not even taken an oath with you because we're going to do that when we're ready to proceed with you. So I want to take the opportunity to firstly apologize that we had kept you for so long, and you are interacting with a discussion that you are not part of, and the discussion is about you. Must have been very difficult sitting there. So one appreciate also that self-control and discipline. You would have heard and listened to us engage in this discussion, and the members articulating their positions, and I just summarized that. So I'm inviting you in order to indicate to you that we would not be proceeding with you as originally planned, that we had a date with you today and tomorrow. It does look like a date I am so that's a point I want to make, but also having listened to the summary about what I've just concluded on in the statement, we're not going to proceed with you today and tomorrow. And we've made that conclusion. If there will be a need for us to speak to you again, we will indicate that. But as of today, we want to thank you for availing yourself before today in preparing for these 2 days and being with us for this half a day. And again, I apologize for essentially wasting your time in that way that you would have utilized somewhere else. Thank you very much. Anything you want to say?
No, just to say thank you, Honorable Dante and Chair and to the members, and that should there be anything relevant that I can assist with, I'm always willing to assist.
Thank you very much. I think that helps a lot going forward. We will interact with you if there's anything relevant or anything new. Thank you, Sis Nomkos.
Thank you, sir.
Thank you. You are excused. Thank you, honorable members. We'll now take a break for an extended lunch, and we'll be back if you still are agreeing for 2:30. So we'll be back between 2:30 and 3. Let me put it in that way.
That's better, Chair. Yeah.
So that when you are not here at 2:30, we don't look at you and say,
Please.
Okay.
Yeah, but it's not far.
No
Just have to
problem.
fetch my files.
I understand.
Yeah, thank you.
Thank you. Meeting adjourned for now until then. colleagues, we're now going to resume the next session with a different witness. I just need to check first if we have all our things sorted out. Mr. Matabuche, are you connected?
I'm here, Chairperson.
Oh,
I'm
thank
here.
you.
If you can see me, I can just open my camera. I'm here.
Thank you.
Am I-
Thank you.
am I seeable today?
Welcome back. Welcome back. Thank
Okay.
you. I can see you stable. Yes. Thank you. Welcome back. We appreciate your time for this short notice. Thank you for that. I will now immediately, without wasting any time, hand over to Advocate Mpofu to interact with you. Thank you.
Thank you, Chair. Just give me 1 minute.
In the meantime, please be reminded that you're still under oath, Mr. Matabuche. Just as Advocate
Thank you, Chair.
is
Noted.
still sorting himself out. You'll be ready just now.
Thank you. Thank you,
Thank you.
Chairperson. Good afternoon, Mr. Matabuche.
Good afternoon, Advocate Mpofu and PP and the legal team. Good afternoon.
Thank you, sir. Thank you for availing yourself at short notice. Yesterday we had wanted to call you today anyway, so that we could speed up things. But we will go for as long as you are willing to let us go today. If there's a need to go slightly over 5 o'clock, will you be able to do so?
Yes, I think it's 5-6 that we're in Mpofu.
The latest. Okay, thanks.
Yes, please. Yes.
Thank you very much. Now, what we need to do, you have been called effectively, according to the evidence leaders at least, to deal with 4 separate reports. Those that were raised with you at the beginning of your evidence. And those are the CR17 Busasa report and judgments. And then there's the so-called rogue unit judgment and report. And to that extent, your evidence coincides with that of Ms. Mvuyana. And then there was an issue of 382. And then, of course, the Pillay pension matter. Can you confirm that you were involved in all those matters to whatever extent?
Yes, when Mpofu, I was involved as the chief investigator that supervised the investigators who dealt with the 3 matters, that is the Avin Pillay pension matter, the SARS so-called rogue unit, and the Friede 2 report. However, Bosasa was the lead investigator because it's an EMEA.
Oh, I see. So yes. In the other 3, you had you are supervising the actual investigators and or senior investigators, and in
Correct.
Busasa, you were yourself the lead investigator.
Correct.
Perfect. Thank you, sir. I was not aware of that distinction. Right. Well, in that case, then I'm going to start with dealing with the Busasa CR17 matter, but in that sequence, if you don't mind, and we'll see how far we go until such time that we have to go, or if you cannot go any longer, and so on. And then we will deal with the other three. But before I do any of that, we need, I always say to the legally trained witnesses, as you know, context is everything in law, correct?
Correct, Mpofu.
Yes, so we always try to paint the context of your evidence so that even the members know upfront where we're going and who is this person in front of us. Unfortunately, this time, the evidence leaders have done most of that work of situating where you fit in the big picture. But just for the sake of without repetition, and I will ask you questions of that nature to save time in a leading fashion, either because the material is not controversial or because in any event, some of it might have already come through from Ms. Mvuyane and it was not disputed. You follow that?
I do, Mpofu, I do.
Thank you very much, sir. All right. Now, it's already been registered here that in terms of the what I call the pecking order, in a particular investigation, ideally, and we know that this doesn't happen with each and every investigation, but ideally you would have the investigator, senior investigator, chief investigator, that is somebody like you, leading the actual investigation team, correct?
That is correct.
And then above you would then be the executive manager who reports to the COO or has a dotted line to the COO, and then the public protector, correct?
That is correct.
Right. Now, we also established with Ms. Mvuyane that the person who is, with the exception of the Busasa exception that you just told us, the person who would be quote unquote on the ground in respect of such an investigation would be the investigator himself or herself, correct?
That is correct, Mpofu.
Yes, and obviously then they would report to you and check with you as and when your intervention is necessary. And you said something quite important. I think you were asked by Advocate Bawa about the reporting line. Can you just confirm that when it comes to drafts, the investigator can sometimes interact directly even with the PP or the EM without necessarily coming through you. But when it comes to a final, let's say section 7.9 or a final report, then it must go through all the stages that we have already described until it is signed by the PP. Is that correct?
In fact, it works both ways in a way, in that when the investigator starts, it starts with submission of investigation plans, document request letters, all of which have to be submitted through a memo that is prepared by investigator, and then that goes to the CI, which is me, and the executive manager, the CO, up to the PP. So that process, that flow of investigation applies both even for the subpoenas, for the 7.9s and so on. It depends, as I was saying, yes, it depends on the nature of the complaint.
Yes, Thank you. Yes, sorry, I forgot to mention, yeah, even the subpoenas, because they also as far as the legislation is concerned, they are issued by the public protector, but as you say, they then would travel that whole journey. The public protector herself might not know who must be subpoenaed at whatever time. But once you've made those decisions, then it travels until she has to sign the subpoena or a Section 79 or final report, correct?
Correct, Honorable.
Good. Right. And you also made the statement, you said an investigating diary or investigation diary is the life cycle of the investigation. And I suppose that in that life cycle, we can also include the investigation plan as, if you like, the lifeblood of the investigation or the blueprint. And Ms. Mviana explained to us what an investigation plan is. But would you agree with that summary?
Yes, that is correct. I would agree with it.
Right. And for the purposes of this committee, would you confirm the evidence of Ms. Mviana that in actual fact, the deadlines or the original deadlines, because deadlines might change from time to time, if you have what in this committee is called a living document. But the original living document, if you like, is the investigation plan, which is drafted by the investigator himself or herself. In other words, the first deadlines are self-imposed in that document, correct?
It is correct.
And then, of course, we now know, even those of us who have never been to the Office of the Public Protector, we now know that there are all sorts of meetings, dashboard, full bench, past team, what have you. And in all those meetings, then the deadlines might be adjusted. If I don't meet a particular deadline, I might get some serious talking to, but if my explanations are correct, then the deadlines get changed. Even so now the deadlines become negotiated rather than self-imposed, correct?
That is correct,
Yes, good. Can you just very briefly, I know that you are one of the most experienced investigators, having started working in this sector even before 1994, when your particular office was located in the homeland or before 1994. Can you just tell us, without getting into much detail, the various stages which you have played in this sector up to where you are now as chief investigator?
When I started in the ombudsman, I was a junior investigator. Then I became an investigator, I think, around the 90s. In 1993, I became a regional manager in Mabopane, where I had to move from Mabati to Mabopane to manage a regional office, which I was a manager for until 2012, when the office was closed, and I was relocated along with the staff to head office in 2012, I think November, where I became a senior investigator under the GGI, which is Good Governance and Integrity. And I was a senior investigator from 2012 up until 2018, I think June, when I was appointed the chief investigator, the position that I am still holding today. Thank you.
Good. Thank you very much. Yeah. And to cut a long story short, you have therefore been there throughout all the public protectors, from the first one, Advocate Selby Bakwa, to Advocate Mushwana, Advocate Madonsela, and now Advocate Mkhwebane, correct?
Correct.
Yeah. Good. Well, I won't even ask you. You probably don't even know how many investigations or reports you have been involved in, but we can accept that it's a lot in that period, correct?
Quite a lot, yes.
Yeah. And that wealth of experience must have contributed to you being identified as what you've called the lead investigator in such a big and serious matter as CR17 Busasa, correct?
I believe so, Advocate Mpofu.
Yeah, thank you. Okay, you don't have to be modest, Mr.
No, the reason that I believe so is because that had been happening to me even before Advocate Mkhwebane's tenure.
Yes, okay. That you got the what sometimes is called the graveyard shift, that you would get some of the heavy lifting.
Yes.
No, fair enough. Thank you. Right, okay, we will come to that particular report just now. Now, the other thing that you said, which for me really characterizes the evidence that some of the issues I'm going to deal with you, if it was a court case and not an inquiry, after that answer, I would have just said, well, that's it, I have no further questions. But unfortunately, we're in an inquiry, so we have to inquire into the factual issues. But you said last week to this committee, and I'm quoting you verbatim, we may fall short, but we do our best. We endeavor to be fair, and we do our best. We work without fear, favor, or prejudice, notwithstanding some of the comebacks. You remember that?
I remember that exactly.
All right. Thank you. So your evidence, both through this questioning and probably when we summarize and argue at the end of the case, I will be put under that that theme. Now, I put to Ms. Mviane yesterday a proposition that if all the horrible things that the public protector is being accused of in relation to these reports, let's say these 4 that concern you, namely that she was deliberately dishonest, biased, out to get Mr. Ramaphosa or out to get Mr. Gordhan, and out to whitewash Mr. Mahashula and Mr. Zwane, no matter what they had done. Which is the gist of those charges, if that was indeed the case, she could not have carried that out without, to use the word loosely, recruiting somebody like you, Ms. Mviana, into that conspiracy, if it was going to be successful. Would you agree with that?
Yes, I would definitely.
Yes. And for the record, were you ever part of any scheme, conspiracy, vendetta to target a particular focus person of an investigation, such as the ones that I've mentioned, or were you ever aware of such an intention being harbored by the public protector?
No, I wouldn't have been at all, especially because when, if I may just elaborate, when we dealt with matters at the beginning, would consult with the members of parliament who would have brought these complaints as required in terms of us confirming or logging the issues. And I would be part of those meetings, or the investigation team would be part of those meetings. If there were any undertones or any such, I would have known or picked them up for sure. But we were questioning them on why they think were the appropriate institution to can investigate what they were alleging against a particular member of the executive as well.
Thank you. That's quite crucial. Yes, you actually made that very clear. Excuse me, Chair. And I think Ms. Mviane also emphasized that point. When you testified, you said the first thing we do is to consult with the complainant, which is what you are saying now. And I think as a lawyer, you and I know that you cannot pursue a case, whether it's a criminal case, whether it's a disciplinary hearing, whether it's an impeachment process, without hearing from the complainant, correct?
Correct.
And I think that's what you are telling the committee now, that in the case of the Public Protector's Office, a similar process is followed. In other words, even before the Public Protector could execute her quote-unquote conspiracy, she would have to contend with the fact that you and not her have to do the screening of the complaint with the complainant, and only if you, not her, is satisfied that this complaint even merits being taken any further, then the show gets on the road. Is that a fair summary?
It's a fair summary, yes.
Yes. So I think what you're saying is even taking it further than what Ms. Mviane told the committee, in that you're saying that not only would you have to be a member, quote unquote, of that conspiracy, but you would have to be a very important one, because without you, whatever conspiracy the Public Protector might be harboring could not be carried out, because you would have said that this is a nonsensical thing. There's nothing here. There's not even a prima facie sign. It's clearly just a witch hunt, and we should not waste the time of the taxpayer on the money of the taxpayer with it. What I'm saying is that you, obviously, if you are a member of the conspiracy, then you wouldn't say that. You would say, no, let's go ahead, because this is Mr. Ramaphosa, the one we've been looking for, or Mr. Kodan. Understand that?
Yes, correct. But me as an executive ethics code complaint, we don't have an option not to investigate.
Good. Good. Yes. Yeah. No. Okay. Therefore, no. Fair enough. So that question that I just asked you now would apply, obviously, to the non-EMEA complaints, such as the Pillay complaint. Oh no, the Pillay complaint against him, but the one against Kodan would have been EMEA. What I'm saying is that the discretion for you to proceed or not to proceed applies to the non-EMEA complaints, correct?
Yes, correct. But those ones that we call SEM, which are special attention matters, would be complex and crucial ones that then we discuss and we hold meetings in the presence of the public protector, despite them not being EMEA.
Yes, no, okay, fair enough. Yes, I think one of the earlier witnesses told us about the so-called SAM. So for the purposes of Honorable Ngola, the SAM are called, rather, what's the full special what?
Special attention seeking matters.
Okay, special attention matters. Okay, now otherwise known as SAM, Mr. Ngola. Okay, thank you. So once again, thank you for that qualification. So both the EMEA and SAM matters would, firstly, with the EMEA matters, you have no option because the legislation says you must investigate. But with the SAM matters, that decision would be taken in conjunction with the public protector, correct?
Correct, yes.
Thank you. All right. Now, I then just want to take you were told last week, so I want to spend much time on this, that your evidence is really relevant for charges 11.3 and 11.4. To save time, I won't read them back to you because I think Advocate Bauer read them to you or I read them to Ms. Mvuyana. But in a nutshell, those charges relate to deliberately seeking to avoid making findings against certain people and deliberately or deliberately, avoiding to make such findings against others. You remember that? Or do you want me to?
Remember. Yes, I remember. I even remember my response.
Yes. Which, please, can you repeat?
Which was in the negative.
Yes, thank you very much. Yeah. All right. So, as I did with Ms. Mvuyana, I have to say this also for the benefit of the members and the members of the public. My questions to you are not necessarily aimed at establishing, for example, that the so-called retirement of Mr. Pillay, which was like a 1 minute special where he quote unquote retired at 12 o'clock and then in 1 minute past 12 he was re-employed. It's not necessarily to show that that was a sham, because I think that should be obvious to anybody. The purpose of your evidence here is to determine whether or not in the process leading up to that so-called retirement, any legal prescripts had been breached. You understand that distinction, correct?
Yes, yes, I do. Yes, I do.
And do you agree with that is the emphasis? In other words, you're not here to tell us whether it was a good thing or a bad thing for Mr. Pillay to retire, or to retire to fund the education of his children or whatever he claimed. You are just here to check whether, as far as that retirement is concerned, and even assuming that it was warranted, it breached any law, the PFMA, the Constitution, the Pensions Act, the Public Service Act, and those kinds of prescript, correct?
Correct.
All right, and that goes for all the other investigations, Busasa. It's not for you to it's not for you to tell us whether it was a good thing or a bad thing for the funders of the CR17 campaign to give R1 billion or whatever amount for him to become the president of the country and the president of the ANC. Your focus is only whether in receiving those funds, the Executive Ethics Act was breached, or any other obligation to declare and that kind of thing. Correct?
It is correct, Reverend Mpofu.
All right. All right. Just so that those people who are inclined to send you nasty WhatsApps, they must just know that your job is actually much more boring than trying to accuse anybody of anything. Yours is simply to look at whether the prescripts of our republic have been followed, correct?
That is correct.
Right. And in doing so, it doesn't matter if it's somebody that you like or dislike, whether you like me or the chairperson or anyone else. Once a complaint has been raised, you just have to disabuse yourself of that liking or disliking and simply look at whether me or the chairperson followed the rules that bind upon us. And the answer is either yes or no, correct?
That is correct.
Right. All right. Then there's also, there's some interference. I don't know whether it's.
Yeah, we are attending to it with
Okay.
Mr. Ngoma.
Thank you, Chair. Right. Now, I just want to go to the issue of jurisdiction, both broadly speaking, but also in relation, also because it arose in the Busasa matter, which I'm going to start with. It is correct, is it not, that apart from speaking to the complainant, one of the first things to be done, obviously, in any matter, is to determine jurisdiction, correct?
Yes, and we do so by checking the applicable legislation.
Yes. Because again, if you come to the examples I was making, let's say the chairperson has transgressed the rules, which of course we know he would never do. But even if he has transgressed them in multiple and daily fashion, very unlikely, then yours would be, it wouldn't matter if he has transgressed them 1,000 times, if indeed you find that you don't have jurisdiction. It's a matter that falls in the hands of the police or someone else, correct?
That is correct.
Okay, and as these examples are getting more gruesome, I will use someone else, otherwise I'm going to be muted. So the point that I'm simply making is, yes, the complainant, the screening, or what I think Ms. Mviana called the preliminary investigation, involves typically, obviously not in every case, involves speaking to the complainant, but also ensuring that the public protector has jurisdiction in terms of the legislation, as you correctly say, correct?
That is correct.
And the powers of the public protector are located in Section 6 of the Public Protectors Act. That's really what you are doing. You are just checking against Section 6, and where Section 6(1)(a) is my favorite one, the one that gives the wide ambit of your powers, starting from discourtesy, or
Capricious.
Yes.
Yes.
And discourteous and capricious conduct, right up to the hardcore stuff like corruption and all that, correct?
That is correct.
Yes. So I was describing it to one judge like that, to say that actually the powers are so wide that even if a civil servant just doesn't greet me, I can go and report them to the public protector for being discourteous, correct? Well, I'm sure you haven't had cases like that, but just to make a point, I'm saying that it moves from the mundane to the serious, correct?
That is correct.
Right. Right. And in the case of the Busasa matter, the issue again was a serious matter of let's say, ranging from the failure to declare a gift to possibly criminal conduct in the form of money laundering, which is some serious business, correct?
That is correct, as the complainant had put it to us.
Yes, the complainant in that particular case, Mr. Musima Emane, the then leader of the DA, had, at least in his specific complaint, alluded to the criminal conduct of money laundering, correct?
That is correct.
Yes. So, like the Pala matter, which I know you're not involved in, the most serious allegations also involved the breach of PRECA and money laundering statutes of South Africa. Let's not necessarily get technical, correct?
Correct, yeah.
Thanks. All right. And either you know this or you don't, but those matters, if proven, would have, in the case of a president of the country in particular, then amounted to, let's say, to be fair, possible impeachable conduct. In other words, if a president of a country was involved in criminality, at least even a first-year student would tell you that that may, and I'm being generous, invoke a further breaches of the Constitution, such as Section 89 of the Constitution, correct?
Correct, yes.
Yes. So the matters were serious not only because of the seriousness of the offenses, but also because of the highness of the office involved, correct?
That is correct, yes.
Right. Thank you. And it is in that context then that I was giving you that compliment, that to be entrusted with such an investigation, I cannot think of a more serious investigation than the Busasa one, other than maybe the Pala one. So it means that you were one of the people who have demonstrated and experience in this area, correct?
Yes, but if people were to remember, I tried to refuse to take it at some point, to say I'm swamped and can it go to somebody else?
Thank you. Yes. No, I know the feeling, yeah. And she wouldn't take no for an answer, I suppose.
That's why I was in it to the end.
Yes, thank you. All right. Right, okay, now having laid that basis, then I think it's fair then to say to the members, let's then go to the specifics. Sorry, Chair, I need to. Oh, we're going to have trouble here, Chairperson. I see that the version that I'm using is not properly paginated. Tsepo, I don't know if you'll be able to assist me to find the Busasa documents. And I'm looking specifically for the report as well as the section 7.9 letter. While Tsepo and my team are looking for the correct reference, but you can confirm that the report was issued by you and the public protector in
July, I think 19 July.
19 July 2019, correct?
Yes.
Yes. Yes, thank you. Yes, that's correct. And thank you so much, sir. What's the front page report? What's that page number? Oh, okay. Sorry, I thought it was me, just me. Okay, there's no page number. So how do we identify it? We'll use the paragraphs, yeah. I think does that mean it hasn't been loaded? But it's not paginated. Okay, that's fine. We'll sort that out. We'll check. We'll just use the paragraph numbers for now. Okay, but for the members to find it, I think at some stage we'll have it paginated. Thanks. Okay, I'll just read snippets, which will give a full picture. If you go to, if you can go to paragraph E under the executive summary. Yeah, sorry, go to G. Okay, the parts that I'm jumping are the well-known parts where Mr. Maimane posed a question in Parliament about members of the family benefiting, and he had a receipt or something, and the president responded to say that he had looked at his son in the eye, and so on and so on. And if it turns out that there's an illegality, he'll be the first one to take his son to the police and all that. But the part that I wanted to deal with is Mr. Maimane's complaint, which is covered in G, where Mr. Maimane says, the report says, Mr. Maimane in his letter attached below further stated that it is his concern that the rest of the facts reveal that there is possibly an improper relationship existing between President Ramaphosa and his family on the one side and the company, African Global Operations on the other side. The nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises the suspicion of money laundering. We've already covered that. The alleged donor is further widely reported to have received billions of rands in state tenders, often in the fashion, or rather, often in irregular fashion. And then what follows there is the actual letter of Mr. Maimane addressed to Office of the Public Protector, Advocate Busisiwe Mkhwebane. We won't go through that letter. As I say, it's also well known in the public domain. Do you remember that?
Yes, I do, Advocate Mpofu.
Right. And just after the letter, Tsepo, was Roman 6. Right. After the signature of Mr. Maimane, it is then indicated that another similar complaint was lodged by Mr. Floyd Shivambu, MP of the EFF Deputy President, as well as an anonymous complaint from a whistleblower on the 28th of June, 2019, who is not a member of parliament and therefore precluded from lodging a complaint in terms of EMEA. I then decided to consolidate the two complaints into one investigation for administrative purposes. And then it spells out what Mr. Shivambu was complaining about, which is largely similar. I won't bore the committee with that. But the point I wanted to highlight there is a point that was made yesterday with Ms. Mvuyane, namely that even though there was a complaint against the president, which came from a member of the public or whoever, the anonymous complainant, that one had to be discarded because it did not come from a member of parliament, correct?
That is correct.
All right. And next, just go to the next letter, just to show it. We want to read it as well. Okay, so that's the complaint letter just go further down. Yeah, that's the complaint letter on the letterhead of the Office of the Chief Whip of the EFF, signed by Mr. N.F. Shivambu, MP. So that was the second valid complaint, correct?
That is correct.
Right. And again, I won't go into the gory details of how you got there, but just to give a flavor to the members of your findings, if you go to the paragraph AA, Tsepo, that's just, it's like double A. Further down. Further down. Yeah. No, it's further down. As after F in that series. Yeah. Yeah. Okay. So I'm jumping just to, as I say, just to give a flavor of what the findings were. One of your findings was that the allegation that on 6 November 2018, during the question session in Parliament, President Ramaphosa deliberately misled the National Assembly is sustained, correct?
That is correct.
And then let's just jump to DD, please, Tsepo. No, sorry, start with CC, because that's important. We're going to go. You'll remember one of the controversial issues, both in terms of the jurisdiction and the criticism that the president leveled on the public protector, had something to do with the question as to whether he personally benefited from these donations. You remember that?
I remember, I do.
Yeah, yes. I think that's one of the main issues. And then at CC, it says, you say, and again, like with Ms. Mviana, when I say you, I know that the report is that of the public protector, but also I'm using you in plural because you were the, shall we call it, yes, the drafter and in this particular case, also the lead investigator. Yeah. Okay.
That's correct.
Thank you. And in fact, I prefer your word, is even better. You were the drafter, as Ms. Vianney explained. Actually, it's you, the investigating team, that drafts these documents. Of course, the PP has the final say and she makes changes and all that. And she owns it. She's not trying to run away from the ownership of the report, but it is drafted by people like yourself, correct?
That is correct.
Right. Okay. Now, here you then say, President Ramaphosa, as a presidential candidate of the ANC political party, received campaign contributions which benefited him in his personal capacity. He was therefore duty-bound to declare such financial benefit accruing to him from the campaign pledges. Failure to disclose the said material benefits, including a donation from AGO, that's African Global Operations, I think, otherwise known as BUSASA, correct?
Correct, yes.
And then you say that is a breach of the code of ethics, correct?
That is correct.
Yes. And then a DD is another important finding you made where you say, I have evidence which indicate that some of the money collected through the CR17 campaign trust account was also transferred into the Ramaphosa Trust Foundation account. So those are two of the crucial findings in respect of that finding that we referred to earlier in AA, correct?
That is correct.
Right. And then let's go to the next AA, that is under C. I'll also just read the finding, and then I won't read the rest of the narrative. There you say the allegation that there is an improper relationship between the President Ramaphosa and his family on the one side and the company African Global Operations on the other side, due to the nature of the 500,000 payment passing through several intermediaries instead of a straight donation towards the CR17 campaign, thus raising suspicion of money laundering, has merit. Now, I want to, you remember that finding?
I do.
Yes, but the emphasis on that finding is just to emphasize the fact that you knew your limits. So you did not find the president guilty of money laundering, and all you could say is that it raises suspicion. After that, it would have to be the NPA or the police or whoever who has to take it forward, correct?
That is correct.
So even if you actually had a photograph of the money laundering, it would be outside of your jurisdiction to quote unquote find him guilty. You would have to refer it to the appropriate authorities, correct?
That is correct.
All right. And that is why if you go to the remedial action, let's go just further down. This is the summary. This is not the remedial action section, but just the summary thereof in your executive summary. What you recommend, having made those findings, is really quite straightforward. There's another AA. No,
Advocate Mpofu, if you give her the page number at the bottom of the page,
I don't have that.
is it not at the bottom right-hand corner of your?
No, it isn't. But it's, you remember the one that I just read, the DD. Yeah, there's just 2 or 3 paragraphs after that.
No, before that.
Yeah.
Yeah.
That no, go further down. There's another AA. Okay, your numbering is okay. Good. All right. Thanks. Sorry, it's not your fault. I think the numbering is, if you don't have the page numbers, yeah, it repeats itself. Thanks, Chapo. So, so in that AA, it says within 30 working days of receipt of this report, the Speaker of the National Assembly, this is remedial action directed at the Speaker of the National Assembly. Within 30 working days of receipt of this report, refer His Excellency President Ramaphosa's violation of the Code of Ethical Conduct and Disclosure of Members' Interests for Assembly and Permanent Council members to the Joint Committee on Ethics and Members' Interests for consideration in terms of the provision of paragraph 10 of the code. Again, my emphasis there is that you could not yourself say, for example, that the president has breached the declaration codes and therefore he must be suspended from parliament or whatever it is. That's not your province. Yours would be to send it to the appropriate structures of parliament for consideration, as it says, correct?
That is correct.
And if they find him guilty or not guilty, that's that's not your business. You would have then referred the matter to the appropriate structures, correct?
That is correct.
Yes, because again, that is something that is not well understood, I think, by many people. For example, in the CX report, I know you are not involved in that, that if you're recommending for Parliament to look into an amendment of a constitution or a statute or whatever, you are not prescribing if the consideration doesn't pass the 2/3 majority or whatever the prescript is, that's the end of it. You are out of it as the public protector. It is that institution that must then process the thing, correct?
That is correct.
Yes, that you in the public protector, you are not mad people who can prescribe that the constitution must be amended no matter what, whether it's 10% or 67%, doesn't matter. It must just be amended. That's yours is to propose, correct?
That is correct.
Right. Right. Then just again to round off that, I won't read the other things about the members and publication of the donations received by the president. Oh yeah, no, let's read CC. You then said that within 30 working days of receipt of this report, the National Assembly Speaker must demand publication of all donations received by President Ramaphosa because as the then Deputy President, he was bound to declare such financial interests into the members' registrable interest register in the spirit of accountability and transparency, correct?
That is correct.
Okay, I've already made the point there. That's another referral there. And then coming to the issue of money laundering, the criminal activity, alleged criminal activity on the part of the president. This is again to confirm what you and I had discussed earlier. You said within 30 working days of receipt of this report, the National Director of Public Prosecutions is to take note of the observations contained in paragraph 17.3.1, as well as the recommendations contained in paragraph 77.3.3 of this report, and in line with section 64C Roman 1 of the Public Protector Act, conduct further investigation into the prima facie evidence of money laundering as uncovered during my investigation and deal with it accordingly. Again, without sounding like a broken record. You couldn't find him guilty or take him to Hoshimampuru prison or anything like that. All you could do was to ask the NPA to investigate this further and either charge him or decide not to charge him or whatever, and the court to also convict him or acquit him or whatever. That would be out of your hands, correct?
That is correct.
And then lastly, you said the National Commissioner of the South African Police Services within 30 working days of receipt to investigate criminal conduct against Mr. Gavin Watson, the late Mr. Gavin Watson, for violation of Section 11.3 of the Public Protector Act by lying under oath. And that was in relation to the conflicting evidence, affidavit evidence of Mr. Watson as to exactly who he gave money to and how many people and how many candidates of the ANC had given money to, those kinds of issues, correct?
That is correct.
Right. Now, that's, I want, as I say, I'm just skimming through the report to get the highlights because we're not here to review the report. But the crucial issue I'm driving to is this. All these findings, recommendations, what have you, were they based on your conspiracy to get into Mr. Ramaphosa, or do you have anything against him, or were they based on the evidence before you?
They were based on the evidence. As it is, having the file on my left, on which all of this that we put in the report was gleaned from. You know, we took it from the file to put it in the 7.9 in the report.
Thank you very much. And I'm glad you have it there. Well, you are lucky. The rest of South Africa don't have access to that file. It has been sealed. But be that as it may, the point I really wanted to make is that you, and I don't even want to know whether this is true or not, but you personally might be a big supporter of President Ramaphosa, and you might like him and be a member of the disease called Ramaphoria or whatever. But whether you like him or not personally, you would have to do your professional duty and follow the evidence, correct?
That is correct.
All right. All right. Now, let's then get to that big bundle that is sitting on your left there. And unfortunately, we can't, at this stage, deal with it in much detail. Some of the issues will be dealt with when the public protector testifies, which is around the corner. But for now, can you just confirm to this committee that particularly the email evidence, you were lucky enough to be provided with email evidence that showed the movements of the money in some minute detail, correct?
Yes.
Maybe not all the money that was donated, but you would have been able to see that there was 20 million rand, which was transferred by, I was going to say Mr. Chabalala, but he's not a billionaire. By somebody who's a big business person, and then that 20 million rand got into the account, and then half of it went to buy T-shirts, the other one to hire buses and all that. I'm just making it up, but you would be able to trace some of the money to that minute detail. Recipient, functions, date of distribution, and maybe another donation from the Mr. or Miss X. Is that a fair summary of the type of evidence that is contained in those emails on your left?
Yes, that is subpoenaed information, if I may say.
Yes. Right. And so this issue, which I said is very central, was central to this question as to whether President Ramaphosa, A, benefited personally, and B, knew of the movement of the money. The conclusions you reached, which we referred to earlier, were based on that evidence, correct?
That is correct,
Right. And more crucially, we'll come to the court judgment, because these proceedings here are mainly based on court judgments. The evidence showed not only that President Ramaphosa must have known about the money movements, but that some of the money, A, was even donated by him. So he obviously knew about that one. And also some of it went through his trust, correct?
That is correct.
All right. And some of the people you spoke to included the people, there's somebody who plays a role called Mr. Berjani Chauke, who was doubling up first as Mr. Ramaphosa's advisor in his presidential office by day, but at other times he was the chairperson or manager, quote unquote, of the CR17 campaign, correct?
I think if I may correct you there, we met with campaign managers, I think, and he was one of them.
Yes, yes. No, I understand that. You met him in that capacity as a campaign manager, but I'm saying then and now he is also, or even in this documentation, he was described as Mr. Ramaphosa's advisor. In other words, in his government capacity. Correct. You may not have known that, yes, but he was, let's just, for your purposes, he was described as his advisor, correct?
That is correct.
Okay, that's fine. No, we'll deal with the details later with the public protector. Right. All right, we'll come back to then. Oh yeah, sorry, just for the sake of completion. Yes, there's a long list of documents which we won't go through. Sorry, it's 4.3.4, Tsapo. Right. Sorry. Right. Okay, I'm jumping the correspondence and all that, but there's a lot of it. I think there are like 36 items. But there was, at least even those of us who don't work in that space by now, we know what a section 7.9 letter is. You issued a section 7.9 letter. Just go slightly up. Yeah, thanks. I wasn't sure myself which one is up or down, but that's good. All right. Section 7.9 letter issued to His Excellency President Cyril Ramaphosa MP dated 30th May 2019, correct?
Yes.
And his response thereto, again, we now know what that is. But the point I was getting to is 4.3.4, which is, okay, sorry. Yeah, if you remember, we see that the subpoena was dated, not subpoena, the 7.9 was dated 30th May 2019, and the response was towards the end of June 2019. Whether from memory or from those dates, would you remember if the president then asked for an extension, which must have been granted?
Yes, he did ask for an extension, Reverend Bofu.
And was it granted?
And it was granted, yes.
Okay. And who would have granted that extension, the public protector or yourself?
The public protector, obviously, because we canvass it with her.
Yes, thank you. Anyway, okay, fine. Then the issue was the people you interviewed, we'll just skim through quickly. Because Mr. Petrus Fenter, I suppose, who works for Busasa, interviews with Mr. Gavin Watson and Natasha Olivier on 25 March 2019. Interview conducted with Mrs. Bejani Chauke and James Motlatsi. That's another leader of the CR17 campaign on 6 March 2019. Interview conducted with Ms. Donay Nicole. That's also someone who works at the president's office in the presidency now, but was also a leader of the CR17 campaign. And then interviews with some lawyers, Mr. Faber and Mr. Chrobla. Those are the people who handled the money. And then meeting with His Excellency President Ramaphosa on the 1st February 2019 and 30 May 2019. Is that an indication that you held more than one? You held two meetings with the president himself?
Yes, that is correct. The first one was to discuss the initial letter of inquiry on the matter. And the second instance is when we delivered the section 7.9 to his office, because the team had felt that it would be courteous for us not to send the sheriff or the messenger, but to deliver and take the president through the section 7.9, which the PP did.
Right. Yes. And we have the recording of that meeting. I don't know if it was uploaded, but if it hasn't. It will be uploaded before the public protector's evidence. That's fine. But it just confirms what you've said for the sake of completion, that it was a matter of protocol. If it was me who was accused of all these things, you would have just sent the section 7.9 with the sheriff or the police or whoever. But because you are dealing with the president of the country, the protocol demanded that as a matter of respect, the public protector herself took these documents and delivered them to the president, correct?
That is correct.
Right. And there was no legal obligation on her to do so. She could have sent the sheriff or anybody like that, but it was just a courtesy, correct?
That is correct.
Now,
Okay, Mr. Matabuke.
sorry, Chair.
Mr. Matabuke.
Chair. I'm here, Chair.
Yes, there's something we don't know whether it's a document you're paging closer to the mic because we can see your mic.
Sorry, Chair. Is the document, sorry, Chair. Sorry.
Okay, thank you. Is it that big? It's making noise for the whole country. That's sealed document. All right. Now, I'm just jumping to 5.1.10.9.6 of the report. This is now coming from the meetings. Oh, sorry, did you attend the meetings with the president?
Yes, I did, Advocate Mpofu.
Okay.
Along with other senior officials of the offices.
And the PP?
Yes.
Thanks. Okay. Yeah. Also, who else was there, if you remember? I think Ms. Baloyi.
Yes, Ms. Baloyi, Ms. Mohaladi, Mr. Sakhalwe, and I think the late Mr. Sibusiso Nyembe, and the PP's PA, I think, if I recall.
Yes, thank you.
Sorry.
And then at 5.1.10.9.6, yeah. You say that President Ramaphosa also stated that upon returning to his office in 10 days, okay, this is now after the whole my money debacle, after he answered the question in Parliament, stated that upon returning to his office in 10 days following the question session, that he was informed by one of his advisors, Ms. Done Nicole, that the account that Mr. Mayomane had referred to, EFG2, was an attorney's trust account that had been used by the CR17 campaign to raise funds for the campaign to advocate for his election as president of the ANC at the organization's 54th National Conference in 2017. You remember that? Uh-oh.
Yes, I remember that.
Oh, okay, sorry. I thought the file had blocked the whole thing now. Okay. Then the next one is, according to President Ramaphosa, a deliberate decision. This is very crucial because this was the main defense here. According to President Ramaphosa, a deliberate decision had been taken by himself and those leading the campaign that he would not be involved in fundraising, even as he would address meetings and have a few dinners with potential funders. These meetings and dinners with potential funders were used as occasions where he would have outlined his vision for the ANC and the country, not just for the ANC. In other words, it was understood that his presidency of the ANC would lead to the presidency of the country. Do you remember the president saying that was his evidence?
Yes, I do remember that.
Yes. Okay, I'm jumping through. All right, okay, let's leave out some of these details. Yes, then let's go right through to 5.22. That's many pages. Oh, thereafter. Okay, after analyzing a whole lot of things and emails and what have you, then you say at 5.2.22, okay, Chair, I'll just read it because while we're waiting. I'm sure, Mr. Matabuche, you don't need to see it on the screen because your memory will be fresher than all of us on this. It says, President Ramaphosa received, quote, assistance from any source other than the member's party, which benefits the member in his or her personal and private capacity, because as presidential candidate for the ANC political party, he received campaign contributions which benefited him in his personal capacity. Being the deputy president of the country and a member of parliament at the time, President Ramaphosa was therefore duty-bound to declare financial benefit accruing to him from the campaign activities. And I think that's just important for two reasons. Your finding, is it not true, was not based on President Ramaphosa as president of the country, which he was by the time you were investigating. Because we all, well, no, we don't all know, we all should know that the president is not a member of parliament. But it was based at a time when he was only the deputy president of the country and an MP, hence the declaration obligations applied to him, correct?
Correct, Rimbovu.
Right. So in the run-up to the ANC conference of 2017, he was the deputy president of the country and a member of parliament, correct?
That is correct.
Right. And then 5.2.24, this point we've already made, but just for the sake of completion, he said, I have evidence which indicates that some of the money collected through the CR17 campaign trust account was transferred into the Cyril Ramaphosa Foundation account. That's came from that evidence that's making noise for us, correct?
Correct. But the evidence is not here. This is just my file.
All right.
Yeah,
All right.
maybe at that point, can we take a break?
Okay.
Before somebody else forces us to take a break.
Yes, I know. Chair, can I just ask one question, just so that I don't come back to this? I know that that time is coming. Yes. Okay. Just the last part. Go to 5.3.10.25. Yes. Okay. I'll read these paragraphs together to save time so that we go to the break and then you'll just confirm. That completes the picture. Then we'll come back and deal with the judgments. 5.3.10.25 says, notwithstanding the unanimous statements by the CR17 campaign managers to me, that means to you, all of you, that it had been agreed that the identities of the donors and the amounts donated by them should not be disclosed to the President Ramaphosa. Evidence adduced has revealed the contrary. So here you were referring to the denials by I almost blame the evidence leaders in vain. By the campaign managers, evidence at your disposal that revealed that those denials were not true, correct?
That is correct.
And this is an important factor we will deal with when we deal with the judgment. And then it says, you say, evidence adduced in the form of emails, invitations, and instructions confirm that President Ramaphosa was constantly informed of the activities of the CR17 campaign by the campaign managers, whereupon his advice and approval on specific matters would from time to time be sought. Did that also come from the evidence?
Yes, that is true.
And then the last one says, I have therefore established that in addition to having met with the potential donors during the banquet functions, where he delivered keynote addresses, evidence further confirmed that President Ramaphosa had had further and broader interactions with the donors, some of whom he knew very well. So from the evidence you had, it was clear that this version that the president was, what do you call it, shielded from knowing the donors, because remember, that's where the crux of the corruption or potential corruption charges come from, that I will donate, and then because he knows that I donated to his campaign, he will remember me, quote unquote, when he becomes the president. That the version that was prevented by this Chinese wall, quote unquote, between him and the donations was actually false, correct?
I'd rather not comment.
No, okay, maybe I'll put it in a more palatable way. The evidence before you showed that the version of the president, or rather, let me put it positively. It showed that he, in addition to having met with potential donors, where he delivered keynote addresses, that he had had further broader interactions with the donors, some of whom he knew very well. That is what was revealed by your evidence, correct?
That is correct, yes.
Thank you. Then there you have the evidence of Mr. Andile Ramaphosa. We won't go into that. Chairperson, yes, that's the, oh, sorry. I have just one more. When we come back from the break, I'll just refer you to one more section and then we'll go to the judgment of the Constitutional Court. Thank you, Chair.
Thank you. We'll pause there for 15 minutes break and be back after 15 minutes. Thank you.
Recording stopped.
Welcome back. Resume our work. Over to you, Advocate Mpofu.
Thank you so much, Chair. Sorry, I've just lost my place. I was saying there's just one more aspect before we move to the judgment. So in the report, we find a copy of the alleged contract between Mr. Andile Ramaphosa and Busasa. We won't go into that. And then summary of the evidence of the late Mr. Watson. But I want to just take you to 5.3.10.61. Right. Okay. Just we won't go. There's a diagram, but I'm just going to take you through some of the information which you found at 5.3.10.61. Do you remember this part where it said, from the evidence received by my office, that means you and the public protector, I can confirm that the 500,000 payment was transferred from Mr. Watson's personal account as part of a lump sum of 3 million rand account into Mioto Trading, eventually EFG2 trust account, which is an attorney's trust account for the CR17 campaign. You remember that part?
Yes, I do agree with both.
And the same. No, yeah. And the next one I won't read is also to the same effect. It's about large sums of money or whatever. And then 5.3.10.63. And this was the type of amounts we're dealing with here. So he said, from the evidence received by my office, an amount of 191,482,227.43 was deposited in the EFG2 ABSA account on 6 December 2016 and 01 2018. And 190 million was transferred out of this account in the same period. So this would have been over a period of about a year, correct?
That is correct.
And that's the example of what I was saying about. It's almost, if you do accounting, it's almost like a debit and credit. So you had evidence of the money coming in, and then obviously the journey of the money over that period until the money is finished, quote unquote, at a particular point, correct?
That is correct.
The same, okay, I'll just take random figures. The next one was 388 million. And then the 388 by a number of rands and cents was transferred out of in the same period, correct?
That's correct.
The next one is 441 million. 441 million until February 2019, correct?
That's correct.
And the other one is 335 million, and the last one is 51 million or so. So, and all the trackings of those amounts was the same as you and I have described before, correct?
That is correct, yes.
Right. Thank you. Okay, then we move to. I was looking for another transaction, but we'll deal with that tomorrow, or we won't deal with it. But I'm just dealing with types of transactions so that I don't deal with all of them individually. But I can't find it now on my pages here. But do you remember there was also reference to some amount which was seemingly solicited from outside of the country? I'm not sure if it was the US or the UK by Mr. Gordon, which also ended up in this CR17 campaign, correct?
No, I don't recall that one.
Okay, yes, no, that's fine. It's probably in the judgments, but we will it had to do with something which was once called the fake intelligence report. That's fine. But anyway, I think we get the picture. Now, the matter then went, or rather, the report, your report was issued. This part every South African knows. The report was issued, the Busasa CR17 report, and then President Ramaphosa took the matter to the High Court in Johannesburg. Is this one? No. Took the matter to the High Court in Johannesburg, where 3 judges sat, and what we lawyers call a full court, chaired by the Judge President Mlambo, and he reviewed your report, and the court found in his favor. I'm just cutting a long story short, correct?
That is correct.
And being the chief investigator, you would have been privy, or were you privy to the pleadings? In other words, the papers that were filed on behalf or by Mr. Ramaphosa?
I was aware of it through our legal services.
Yes. And again, just to save time, I won't go through the gory details of the actual affidavit, but I just want to establish one fact, which is important for the committee, which is that the gist of Mr. Ramaphosa's accusations against the public protector were that all this was just a figment of the public protector's imagination, or yours by extension, and that it was your report was not really based on the evidence that you have just shared with us, but was based on some vendetta and political witch hunt. You might not have used those words, but it was that it was not a genuine outcome, correct?
That is correct.
And that is what the only important thing for the purposes of this committee. In other words, that which the judges confirmed and that which Ms. Natasha Mazzoni later used as part of her motion for us to be here today, the origins of those allegations of bias or political motives or whatever was Mr. Ramaphosa himself in his founding papers, correct?
That is correct.
Yeah. And yes, and so like the money, it doesn't matter how many times it travels from the donor to the recipient, but the original source of the allegations that have brought us here is, I think this was confirmed by Ms. Mviana as well yesterday, in each case would be the applicant, the person who actually brought that matter to the court. We can't blame the court for it, as it were. You would know that as a lawyer, correct?
That is correct.
Yes. Okay, well, we tried to impress that on the committee so that we get the source of the allegations that have brought us here. But we were told that that source is quote unquote irrelevant. But there you are. Now, and then of course, just for the sake of completion, the public protector would have then put a respondent's answering affidavit with input from you and others who participated in this, obviously refuting those claims of bias and political motive and all sorts of things, correct?
That is correct.
And there was another affidavit by a Mr. Julius Silomalema, who supported the coming from the party that was part of the complaint, who also participated in that litigation, correct? To your knowledge?
That is correct. Yes, it is correct.
Right. Okay, so that sets the scene. I won't go into those affidavits in detail, Chair. They are before the committee. So I'm jumping now from the report to those affidavits and then the judgments. Just to save time. Sorry, let me just check how we're doing for your time. Okay. All right, we'll try and release you even before that time, because I was told that you have some engagement. Right, so let's then go into the judgment quickly. Again, for the sake of time, I won't go into much detail on as far as the first judgment is concerned. That's safe to say that that judgment found, among other things, that the report must be set aside because yes, I was just looking for an expression that will characterize the kind of sentiment. The judges said, counsel for the president submitted that the conduct of the president in this case shows a quote, a reckless determination to make an adverse finding against the president. So that is what the president accused you of doing, you and the public protector. A reckless determination to make adverse findings against him personally, correct?
Yes, and it's unfortunate, if I may say, that can go.
Yes, no, sorry, I know it must be hurtful. I did ask Ms. Mviana yesterday how such statements make you feel after all the blood and sweat, but we'll deal with that at another stage. Let's try and be strong for now. and put the feelings aside. And on the basis of that, of those kinds of comments, and there are many of them, it was said, these conclusions of yours were reached irrationally and recklessly, and without an open mind. And the like, and that for that reason, the public protector, not only should the report be set aside, but that she should be directed to pay the president's cost on an attorney-client scale. In other words, on a punitive scale for daring to trouble him like this, correct?
That is correct.
And so that's then that outcome, which I've paraphrased, which then becomes the platform for Ms. Mazzoni and her fellow travelers to bring us here, correct?
That is correct.
Right. Then the matter went to the Constitutional Court. The public protector appealed those findings, and some of them which are worse than what I've just said, directly to the Constitutional Court. You remember that?
I do remember, yes.
Okay, and again, I won't take you through the pleadings of each side, but anyone would now be able to work out. The public protector was saying those findings are wrong, and the president was saying no, those findings are correct, and they are warranted. She is indeed, you and her and other people were determined to get him for political, well, let me not put words in the mouth of the president. I think it was Mr. Gordhan who claimed specifically political motives and corrupt and state capture and all those things. You remember the allegations made in the Pillay and so-called rogue unit allegations that actually what motivated you is that you were part of the state capture gang and corruption mongers, correct?
Yes, I do remember, yes.
Okay, fine, we'll deal with those separately. The president said you have ulterior motives, but I'm not quite sure if he explained, unlike Mr. Gordhan, what those ulterior motives were. Fine. Then when we get to the Concord judgment, this is how I want to approach it in the period that is remaining. Effectively, you would be aware that, thank God, on the part of the public protector at least, the Chief Justice Mogoeng found that judgment of the High Court was baseless and had to be rejected for various reasons, which I'll go into now. But the majority judgment agreed with the High Court. You are aware of that, correct?
Yes, I'm aware of that.
Thanks. And needless to say, I think I asked one of the witnesses, but just for the record, of those two judgments, you agree with the judgment of Mogoeng, Chief Justice, correct?
Obviously.
Thanks. Yes, no, that's why I was saying at the risk of stating the obvious, because he actually, and this is important for the purposes of this committee, because if your findings were so outrageous as Ms. Mazzoni would like us to believe, then someone no less than the Chief Justice would not have agreed that you, and I know this was a minority judgment, so but the point I'm making is that no less than the Chief Justice agreed that yours was a good effort and that your findings had good grounds. I know you were saying that the other remarks were hurtful, but I hope the fact that the Chief Justice of the country found that you were justified made you feel slightly better, correct?
That is correct.
Yes. Now, and that goes to the gist really, because this goes to both to this matter and the CX matter. Because in the CX matter, actually, it was not only Chief Justice Mogoeng, it was also Justice Goliath. There were two judges who had a dissenting judgment, but that you were not involved in CX, correct?
That is correct, I wasn't.
Yes. But I think the same logic holds that, well, at least to your knowledge, was Chief Justice Mogoeng impeached for agreeing with your report?
No, he wasn't.
Yeah. And I'll just very quickly, okay, to be fair, let me start with the parts that are against you. I'm just taking random passages. There are oh yes. One of the key issues, before I go to those passages, also just to paraphrase, one of the key issues that arose in this matter was whether the public protector had jurisdiction because this matter concerned, quote unquote, private political party funding. And that issue went, legally speaking, went to the issue of whether the president had personally benefited, which is what the relevant code says, personally benefited from those donations made to the CR17 campaign. You confirm that?
Yes, I do.
And the other issue, where you were lambasted by the earlier courts and this court, was the reference that was made by the public protector to the 2007, yes, to the 2007 version of the Code of Ethics, where she was accused of having amended that code because the applicable one was the 2000 code. So in other words, you and her had once again deliberately went to amend the Code of Ethics. You remember that one?
I do remove.
And I'm sure you found that even more hurtful because that suggested like manipulation and I don't know what on your part, correct?
That is correct.
Yeah. So this is then what the majority said at paragraph 72. Sorry, I don't know if you have that judgment, Tsepo. Okay, good. Can you then go to paragraph 72? No, sorry. Start at 59. I'll start with the hurtful part so that we get it out of the way. Okay, then here, this is what the judges say. But what is more concerning with the report is that the public protector changed the wording of the code by adding, quote, deliberate and inadvertent misleading of the legislature. In other words, you and the public protector went to add words in the code which were not existent. But the truth is that those were the words that were used in the 2007 version that you had employed, correct?
Yes, from the handbook, that is correct.
It's actually from the ministerial handbook, yes. It's not so that you manufactured these words and changed the code, correct?
That is correct.
And when the public protector leads her evidence, I don't want to bore you with the ins and outs of this code because we will attach it to her statement. With your experience as well, can you confirm at least one factor, which is one of the issues we would have raised with Advocate Madonsela, because she is involved in this, that the code that you had used is the very same code that she, Advocate Madonsela, had used in the famous EFF Nkandla case, in respect of which President Zuma, President Ramaphosa's predecessor, was condemned. You remember that?
It is correct. Yes, it is correct. It is like that. And
Yes.
and when we were finalizing our report, that we even had sight of the Nkandla report, which had the very words. Yes.
Yes. So if you have deliberately added those words, then it would also mean Advocate Madonsela did the same to nail, quote unquote, President Zuma, correct?
It would look like that, yes.
Yes. But well, we know the truth is that neither she nor you had actually deliberately used the wrong code. It is because that was the code that had been used by everyone until the legality of the other one was established, correct?
That is correct.
Right. Right. Yeah, that's what I've seen. And now a person in your position who is a servant of the people or in the position of the public protector and the former public protector for that matter, can you be justifiably faulted for using, rightly or wrongly, a version of the executive code which had the endorsement of the Constitutional Court in the Nkandla judgment? Is it fair to do so?
It's not fair, especially when one considers the bona fides behind, the whole investigation and the report that we issue.
Absolutely, thank you. That is the point, really, isn't it? It doesn't matter. Let's say you got the law wrong or you looked at the wrong. So even us as lawyers, sometimes you read an act and you quote it only to find out from further research that it was repealed 2 years later. So the point is not that. The point is whether in doing so, as you say, you were, let's assume you used the wrong code, whether in doing so, you are motivated by bona fide mistake, or whether you were out to pursue the alleged conspiracy. And I think it's the second part that you are offended by, isn't it? Because you don't suggest that you are superhuman, you don't make mistakes.
That's correct.
Right. Then we can go to paragraph 70. Okay, I think that, yeah, well, someone is having a party. Okay, in a nutshell, again, I'll avoid reading for the sake of, in a nutshell, then the majority also agreed that the president did not receive personal benefit. I suppose, even though he became the president of the ANC and the president of the country, somehow he did not benefit personally. That's what the court found, correct?
I'd rather not comment on that, Reverend Pofu.
No, okay, no. I'm not attributing it to you. I'm saying that's what the court found, correct?
Yes.
Yes, thank you. Okay, well, this one, just so that it's clear, we're not attributing it to you. I'll just read it as it is in the judgment, because otherwise I'm sure you would also not want to be much associated with it. But at paragraph 91, it says, quote, in our multi-party system, being the president of a political party, apparently such as the ANC, is not a guarantee to being president of the country. That was one of the findings of the court, correct?
That is correct.
Right, okay. So, as I said, I was doing that for the sake of fairness, so that we start with the bad news, for you at least. Now, the Chief Justice Mogoeng, and I think this is one of his last judgments, and unfortunately, he is lost to the system now. But some of these judgments, they say that these judgments, the minority judgments, you've heard this, I'm sure, as a lawyer, that today's minority judgments are tomorrow's leading judgments, correct? In other words,
that is correct.
Yes. There was a famous Judge Schreiner who fought the apartheid bench valiantly and alone in the 60s and 70s. And all his minority judgments, he just dissented knowing that he was never going to win against those apparatchiks. But all his judgments have now become the basis of some of our most progressive judgments. You'd be familiar with that history from constitutional law, correct?
It is correct.
All right. So this is what Justice Mogoeng says. And I think it's important for me to go through this. Oh, at least there's still a bit of time, yeah. If you forgive me, because for some reason, when these judgments are reported, firstly, we never even get told that there is a powerful dissent. But even worse, you'll never see any medium in South Africa even covering what that contra review, which is not the same as the herd mentality, says. So I want to, both for you and for the members of the public who are not aware, but also just to put perspective on the Mazzoni motion, which is that your report was an outrage. I will quote some of the conclusions reached by Justice Mogoeng, and I'm sure you've read this, so you'll confirm those that you remember and or make your own comment, please. Can you do that?
We'll do it, Winbo.
Thank you very much, Mr. Mataboh. At paragraph 158, Seppo. Let's start at 150. Just for context. He says, I read the main judgment. Oh no, sorry. There's more bad news for you, sorry. Just go a little bit up, Seppo, just for context. So, further up. Yeah. That is the order then of the majority judgment, which was against you. Leave to appeal is granted. The appeal is dismissed. The matter is referred to, okay, that's another case. And no order is to cause in respect of the parties. So at least there was some good news for you there, in the sense that the Constitutional Court did not agree that you needed to be punished. So I hope you'll take that as something positive from the majority, correct? Are you still with us, Mr. Mataboh?
That is correct. I was saying, as well as I think paragraph 3 there, relating to Amabungani.
Oh yes, paragraph 3. Sorry, I jumped that. Yes, for perspective, let me read it. It says the dismissal of Amabungani claim for constitutional invalidity of executive ethics code was set aside. Yeah, yes, that was positive. But also paragraph 6, where the no orders to costs was ordered. Correct?
That is correct.
Yeah. So in other words, the only punitive cost order that remained was the High Court one. You meaning the Public Protector's Office, at least wouldn't have to pay the cost for the Constitutional Court part. Okay, but okay, fine. Then let's go to the good news. 150. That's the one further down. Yeah. So Justice Mogoeng then says, against that background, I read the main judgment written by my brother Chafter J with great interest and thankfully relied on the facts set out in it, subject to contextual modulation, context being everything. And then he said, sadly, we part ways on the approach, the reasoning, and the outcome, save where the contents otherwise indicate. And he then says, this case is fundamentally about at least 2 foundational values of our democratic state: transparency or openness and accountability. It is also about how dangerous to good governance apparently philanthropic gestures or sponsorship could be if the teeth of our integrity, transparency, accountability, enforcement mechanisms are not allowed to checkmatingly bite these potential insidious practices. Let's then jump to paragraph 158. The rest is he's quoting the Ethics Act and all that, yeah. I'm very sorry, Tsap. We can go to 155. Because this then places the public protector's involvement in this. The Chief Justice says the following: central to the complaint was therefore money that was paid to the CR17 campaign, undeniably intended to strengthen the president's prospects of becoming what he eventually became. How the public protector got to investigate the CR17 campaign does not seem to be a consequence of some inexplicable fishing expedition or of being unduly or overly suspicious of the president. Honorable Maimane asked her to look into a potentially compromising donation to the president, which, as stated, we now know was to the CR17 campaign, and alluded, albeit not in so many words, to a possible conflict between the president's official responsibilities and his private interests, by mentioning the billions of rands received by African Club operations in irregular state tenders. Then he turns to the facts. We'll jump that, and the law. You remember that part?
I do, Advent Bofu.
Yes. Then he says at 158, when a vacancy in the presidency of the governing party, and by extension the presidency of the republic, loomed large, the then Deputy President, His Excellency Cyril Ramaphosa, decided to raise his hand. Apparently, a successful campaign for the attainment of that personal ambition or private interest required financial resources in abundance, and a funding mechanism for that race to the top was developed with his blessings. I say with his blessing advisedly, because he too contributed his own money to the kitty. He reportedly addressed fundraising meetings attended by sponsors, and he interacted with some of the sponsors. He does not seem to have been oblivious to the existence and purpose of the CR17 campaign. You remember that?
I do, Advent Bofu.
Right. And we now know the section 96C of the Constitution, which says that members of the cabinet must not expose themselves to a situation involving the risk of a conflict. A mere risk is enough. He says at 162, when people or entities other than the then Deputy President's party gave him sponsorship or financial assistance for the purposes of realizing his ultimate political dream, he was, by accepting help or allowing others to accept help on his behalf, exposing himself to a situation involving the risk of conflict. You are familiar with the section 96, correct?
I am correct.
Then let's jump to 163. And this was a response to the allegation that the president was insulated from knowing the donors. And I think this is the most profound point made by Chief Justice Mogoeng, which is that even if you accept that the president was insulated from knowing the donors were not insulated from knowing him. And those would have been the corrupt ones. And then he says at 163, when the then Deputy President urged and allowed potential donors to sponsor his own ambition to become president of his party, he was thereby exposing himself to a situation that is an incubator of a risk of conflict. Donors knew who they were helping, and if the unethical ones, assuming there are any among them, were ever to desire help or favors from the state, they would know who to go to, the Deputy President and soon to be President. There is an ever-abiding risk of conflict between being financed to become president of a party, the private interest, and one's position as the Deputy President and leader of government business in Parliament or President of the Republic, the official responsibility. It is necessary to emphasize that there is nothing to suggest that the sponsors were somehow interdicted or legally forbidden from informing the real beneficiary of the extent of their individual contributions and even producing proof. You remember that part?
Yes, I do.
And we'll jump paragraph 164. At 165, the Chief Justice then says, it is the Deputy President who, as a matter of private interest, not only wanted to become the President of the ANC, but self-evidently also desired and planned to be the President of the Republic. It requires hair-splitting. It requires a hair-splitting exercise to seek to draw a line between the pursuit of the presidency of the ANC and the desire to rise to the highest office of President of our country. Similarly, it would require unprecedented linguistic gymnastics to seek to draw a line between channeling funds through the CR17 campaign fund to fund the race or campaign to the top and the personal benefit to be derived by the one desirous of the resultant elevation. Do you remember that part?
Yes, I do.
And then we jump the first part of 166, the Chief Justice says, excusing disclosure as a result of the juristic veneer of the likes of the CR17 campaign or its trust account is a sure way of enabling wrongdoing, corruption, or even the so-called state capture. And he says, ascension to raw power or the supreme office enabled by funding sourced by the CR17 campaign was a quintessential personal benefit and a personal achievement or success. Remember that part?
Yes, I do.
Then let's jump to 169. Or 168. For this reason, 167, I'll just read one sentence. That trust or entity was in reality, that's the CR17 campaign, in reality, a proverbial middleman between the financial sponsorship or assistance and Deputy President Cyril Ramaphosa. And then at 168, he says, he lists many things that he did. For this reason, whatever legal personality the president and his campaign managers may have chosen to clothe the repository of his campaign sponsorship or financial assistance with cannot detract from the naked truth that one, he pleaded with potential sponsors to give money in and for his name CR17. And then he says in brackets, explain what CR17 means. It means Cyril Ramaphosa's campaign for the ANC presidency in 2017, close bracket. Then he says, he knew that the money that he was being given and spent on his own ambitious campaign came from an agreed structure known as CR17 campaign, to which he also contributed. And three, he personally benefited from the sponsorship that propelled his campaign to its logical conclusion, the presidency of the ANC. Election or elevation to a position you desire is a benefit. And the benefit is personal because the targeted beneficiary gets to occupy and enjoy the position and all its accompaniments. It is perhaps necessary to state the obvious. The position is not occupied by a group, but by an individual. When the sponsored one attains the desired position, people congratulate him or her because they see him or her as the winner, the successful one. And then in paragraph 169, it says, the foundational values of openness and accountability demand that we pierce through the trust veil that is capable of inadvertently or by design, frustrating the all-important disclosure in his corruption, in this corruption-infested country. Why would anybody not want to know who is helping them? And how reasonable, practicable is that anyway? And why would they want to have their benefactors unknown to Parliament or the public it bears that the refusal to know in circumstances where one is under the duty to know and the consequential failure to disclose is a sure, albeit unintended recipe for corruption under the cover of facilitation of a well-structured mechanism or legal stratagem, again not intended, but having the inescapable effect of evading accountability, openness, and disclosure. I'm sure you remember the part that deals with the code as well. Can we then jump to paragraph 173, Mr. Mataboga?
Correct. We can jump to 173.
Thank you. The Chief Justice then says, referring to the emails, as a matter of practice and law, the contents of an email or a document by X and Y, or sorry, let me just preface this for the benefit of the members. This was in apropos the issue of where did the public protector get these emails and all that, and whether they have been authenticated. And then he says that as a matter of practice and law, the contents of an email or a document by X and Y may, assuming its authenticity is not disputed, be used to contradict and discredit their own oral evidence and vice versa. This extends to the evidence of a recipient of those emails who might have asserted a contrary view. He or she may be similarly discredited. For this reason, the public protector ought to be understood to be saying that the oral evidence of the president and the CR17 campaign managers regarding what the happenings in the campaign with regard to the donors and their donations was effectively belied by their own exchange of emails that revealed that the president knew what they claimed in their oral evidence that he did not know. You remember that part, Mr. Mataboga?
Yes, I do.
Yeah. Right. Then it says about the code at 177. More importantly, as the public protector correctly found. So this is the part that vindicates your report, Mr. Mataboga. More importantly, as the public protector found, when he received or caused others to receive the sponsorship or financial benefit, he was still Deputy President of the Republic and a member of Parliament. The code applied to him fully. He cannot be exempted from the consequences of what he did, then by reason only of the fact that the code personal benefit has worked so well that he now occupies the position of president in line with his and the sponsors' set objectives. Then I'm going to the last three or so. At paragraph 180, it says in favor of the public protector, 179, sorry. The aude alteram partem rule is an integral part of a fair trial process and a fundamental element of justice. How it applies to the public protector must be guided by how it ordinarily applies to court proceedings, civil and criminal. This is in relation to something that was raised in a question by Honorable Sukas to Ms. Mviana yesterday about the learnings that are gained from these judgments. And I referred her to this issue of the double Audi. You are familiar with it, Section 7(9) of the Public Protector Act, Mr. Mataboga.
Correct, I am familiar.
Yes. The Chief Justice agreed with your approach. He says, I disagree with the views to the effect that the aude alteram principle obliges the public protector to inform a party likely to be adversely affected by the remedial action she is minded to take. In civil litigation, judges and magistrates are never under any Audi-induced obligation to inform the parties of the remedy they are mostly likely to give. Sometimes they do make their preliminary views on remedy known to the parties and solicit their views. But this is never done as a result of some legal obligation whose failure to fulfill could result in an injustice or unfairness, which could or would then give rise to the need to vitiate the decision in order or the order of the court. Not even a criminal case is a court. Not even in a criminal case is a court requires by the Audi principle to indicate in advance what sentence it is likely to impose. Justice would be sufficiently served by affording all parties the opportunity to deal with the sentence that may be imposed, regard being heard to the facts of the case and what the accused person would have been convicted of. And then he says, the test cannot be any higher when it comes to the public protector, who does not even have the authority to impose terms of imprisonment on those she investigates. She is therefore only required to have the parties deal with what they consider to be a possible, but not necessarily pre-announced remedial action event of the complaints under investigation being established. Although not precluded to give a hint at her preliminary views on the remedial action, she is not legally obligated to do so. And Section 7(9) of the Public Protectors Act, which really is a codification of the Audi principle, must be understood in this context. I'm sure you would agree, Mr. Mataboha?
Yes, I'm agreeing 100%.
Yes. And,
because even on the 7(9) that we issue, there's a request for extensions and so forth, and we engage further on whatever they need to submit.
Yes, and is it correct? Okay, that when you do, in fact, this is another issue we would have raised with Advocate Madonsela. And I might take advantage of your experience. It's true that during the era of Advocate Madonsela, the Section 7(9) reports were called provisional reports, correct?
That is correct.
I'm sorry, the Section 7(9) letters, which are now issued in the Mkhwebane era, were called provisional reports in the Madonsela era, correct?
That is correct.
Yes, and I think that's very important because, again, in this committee, in terms of both in the CX and FREDE matters, there is some confusion because it is said that the public protector, Advocate Mkhwebane, in one case, sorry, I mixed them up myself. I think in CX, in CX it is said that she broadened the scope of the investigation as compared to the provisional report. I mean, that just doesn't make sense because the provisional report is one thing and then the actual investigation is another. But in the FREDE dairy matter, she's accused of the opposite. Here now, she narrowed the scope of the investigation required by the complaints. I'm reading from the charge, as commenced by her predecessor, Advocate Madonsela, who is said to be irrelevant, without providing any rational or proper explanation. That's what is said. And then at 4.4, it is also said that Advocate Mkhwebane materially altered the remedial action proposed in the provisional report prepared by her predecessor, Advocate Madonsela, before issuing the final report without providing any rational or proper explanation. And I just wanted you to assist the members by explaining that what was known as provisional report is the same thing as a Section 7(9) letter, correct?
That is correct.
Yes. Okay, yeah, we have only about 20-30 minutes. Okay, then at paragraph 182 says the Chief Justice, Had it 182, please, Tshepo. Had it not been for the whistleblower who shared emails with the public protector, it would most likely have never been known that the president and his campaign team presented facts known to be incorrect to the public protector. And with regard to these emails, which enjoyed some attention in the preceding paragraphs, it is necessary to do a recap on the relevant background. The president and the CR17 team chose to and represented to the public protector that he deliberately kept himself and was intentionally and strategically kept ignorant of the donors and the extent of their contributions to the campaign, as well as operations of the campaign in relation to those financial contributors. The public protector subsequently got hold of and relied on emails that belie the president and the CR17 campaign manager's shared version of the president's professed ignorance. What follows is what the president and the public protector said in their affidavits. Then they say what the public protector said, where they said public protector could not possibly have arrived at rational conclusions, blah, 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 all those things. They quoted from the public protector's answering affidavit, which is part of the material evidence presented by Ms. Mazzoni to this committee. And the Honorable Chief Justice then quotes that paragraph of the public protector, which is the version she will give to this committee when she gives evidence. Paragraph 183. After all these accusations by the president, okay, although I'm not going to read it out, just to link it to the alleged irrelevance of the president to this process. The Justice Mogoeng quotes the president himself at paragraphs at 182, 13, 11, 13, 12, 38, 39, 40, 87, 88, 89, and 90 of the president. And then this is the response of the public protector. She says, it is telling that instead of the contents of the email, or rather, it is telling that instead of denying the contents of the email, the president complains about how I obtained the emails to which I refer. I received many documents from anonymous whistleblowers. These emails were provided to my office anonymously and in hard copies. It is for that reason that I have no metadata in respect thereof. However, even if I knew the identities of the whistleblowers, and this is again another issue we raised yesterday here, and the Chief Justice underlines this for emphasis. However, even if I knew the identities of the whistleblowers, I have an obligation to protect them. What the president has to do is to take this honorable court and the country at large into his confidence and explain the contents of these emails. I deny that I obtained the emails unlawfully. Just can you assist us as to how much in your experience as an investigator you rely on whistleblowers and what your obligation is to protect their identities?
I'd say it's almost a daily occurrence, because if one were to check our files, most of our files are even titled anonymous, whereas we know who the whistleblower would be, but we receive them. I wouldn't say how many times, but they are a common occurrence at both.
Yes, thank you. And how seriously do you take your duty to protect those people? In other words, if the president says, well, you have these emails that show that the money went here and went there, instead of saying, no, I don't know anything about such money, says, how did you get that information? Would you reveal to a person like him or any other implicated person the source?
No, we wouldn't. In fact, we have been on many occasions been told to bring the source for cross-examination or for questioning in some of the subpoena interviews that we have with the respondents, and they want to engage with the anonymous complainants, and we've never allowed it.
Yes. And isn't that one of the essential, again, fallacies that people who don't know the type of work that you do will equate the type of evidence you deal with that of a court? I can tell you now, a court would never even look at evidence that, if it cannot say, except in extremely exceptional circumstances, if it cannot say where that evidence came from, that it meets the rules of evidence and so on. But in your type of investigation and inquisitorial process, that is not the case. You are entitled to rely on evidence that is would in a court of law be rejected, correct?
That is correct.
Right. Then that issue we will deal with when the PP testifies, because that's another problem that is completely misunderstood. Then it says we're coming towards the end of this. Okay, I'll read 2 paragraphs so to save time. 187.
Are there people going out and in of your space, Mr. Matabuche, or is the staff members leaving? What is happening?
Oh, you hear, Chairperson, they are trying to force my door open. They want to say goodbye to me, and I've locked myself in.
Oh, okay.
Sorry, Mr. Matabuche. Okay, we're going to release you soon. So hopefully you're not locked in there for too long. All right, 187 and 188, I think it's almost the crux of what the Honorable Chief Justice says. At 187, he says about this issue of anonymous emails. The president says repeatedly that he was not afforded the opportunity to be heard before the emails were finally relied on, that they were stolen or irregularly obtained from the CR17 campaign computers and because they constitute improperly obtained evidence, that irregularity alone is sufficient to vitiate the entire report. Well, unfortunately here, that means he confirmed that they were stolen, quote unquote, from the CR17 campaign computers. Is that what you understood by that part?
Yes, this is how I understand it.
Yeah. And then it says the president effectively acknowledges the existence and admits the authenticity of the emails, which is, he confirms that there are indeed communications between him and among others, the CR17 campaign team contained in the computers of the CR17 campaign. He demands more than once that the public protector should explain to him how and from whom she obtained these admittedly truthful but reputationally damaging emails. Not once does he explain why he and his team chose not to tell the truth, but to rather mislead the public protector as they did. Instead, he says that the emails are in any event irrelevant to the public protector's findings. But that cannot be correct. For not only are the emails relevant, but they also expose the falsehood of the version that the president and the CR17 campaign managers chose to present to the public protector. You remember that?
I do, Adwendorf.
And then the crux at 188, he says, and it bears repetition that the false version is that there was a deliberate plan to ensure that the president does not get to know who the donors were, how much they were donated, and how the financial assistance received for his campaign was being used. The emails squarely belie this assertion. The question we would then be asking ourselves is, quote, he says, why did the president and his team deliberately convey a falsehood on an issue so crucial and inextricably connected to the constitutional imperative to promote and observe the high ethical standards in obedience to the demands of our democratic state's founding values, openness and accountability? He must have known that if the truth evidenced by the emails were to be told, the obligation to disclose the names of the funders and the size of their contributions to the National Assembly and by extension to the public would automatically and plainly be triggered. Okay, thanks. Thank you. Sorry, thank you, PP. Sorry, I almost jumped to this one, paragraph 190. He then says, truth or integrity is, after all, at the heart of the office of the President of the Republic, particularly in relation to his or her constitutional obligation. Deciding to present a version known to be untrue as an organ of state whose constitutional duty it is to strengthen our democracy is conduct that is inconsistent with that high office and the obligations that the incumbent has to uphold, defend, and respect the Constitution. And so is the failure to report the sponsorship of financial assistance from donors that he has addressed and asked to donate to the CR17 campaign. Then this part number 191, lest we forget, we're not dealing here with an average citizen, but with the bearer of specific and frighteningly weighty constitutional responsibilities, including the suspension and non-suspension of the public protector who was investigating him. Sorry, that's part I'm adding myself here. But the Chief Justice said, who is expected and required to lead by example and be above reproach. His office demands of him to be the lighthouse, the pathfinder, the embodiment of and vessel for the enforcement of high ethical standards, particularly the foundational values of our democratic state. In this instance, transparency, accountability, and the supremacy of the Constitution. Like all of us, he has rights, but unlike all of us, he does have special obligations not imposed by courts, but by the Constitution and legislation. It is the President, the number one or first citizen of the Republic, who we are talking about here. His is a distinctive and supreme office in the land that does not permit the employment of extraordinary technicalities when issues of ethics, transparency, accountability, upholding and respecting the Constitution has to be considered and pronounced upon. It is in this context that one is constrained to keep on saying that technicalities must not be allowed to easily frustrate the fulfillment of the core constitutional obligations and the attainment of substantive justice. You remember that portion, Mr. Matabuka?
Yes, I do, Advocate Paul.
And then he says towards the end, and this is an important part for you and your findings that we went through earlier. 192, thank you. The Chief Justice says, it bears repetition that the president carefully and intentionally gave a false version of what he knew to be the case to the public protector. It bears repetition that the president carefully and intentionally gave a false version of what he knew to be the case to the public protector. What he did is highly unethical and a resounding rejection or dereliction of his key constitutional obligations. This is therefore not a question of the president and his team mistakenly putting forward a version, such as he did in the National Assembly with regard to the alleged Bosasa donation to his son, which he subsequently corrected. It is rather a case of a calculated misrepresentation of fact by someone who is confident that the truth would never be uncovered. He says, no wonder the president and his team have made no attempt at reconciling their own version with the emails. The two versions are mutually exclusive or destructive and obviously incapable of reconciliation. And all the president could do and did was to keep on asking the public protector, and I paraphrase, how did you manage to access this well-kept and closely guarded secret? Who gave this painful truth to you? That's the Chief Justice conclusion at the end of that summary, that all the president could do and did was to keep on asking the public protector, Advocate Mkhwebane, how did you manage to access this well-kept or closely guarded secret? Who gave this painful truth to you? Without being forthcoming with any version. Then the last portion relates to this thing about whether she prescribes or refers. And then he says, and this is important, it appears that she acted in terms of Section 646 Roman 1 of the Public Protector Act to recommend to the police and the prosecuting authority to pursue possible charges of money laundering against the president. The subsection reads, and then he quotes the subsection. It says, the public protector shall be competent at a time prior to or during or after an investigation. 1, if he or she is of the opinion that the facts disclose the commission of an offense by any person, to bring the matter to the notice of the relevant authority charged with prosecutions. That's the issue we covered earlier. She can't prosecute herself, but she is obliged by law to refer such criminality to the relevant authorities. Does that capture the section you were looking for that you were referring to earlier, Mr. Mataboga?
Yes, that is correct.
Then the Chief Justice says finally, and this is what she did in relation to the money laundering charge. I hasten to add that she was wrong to have been somewhat prescriptive by couching a referral to the offense in the form of a supervisory order. Hers was to refer, not to monitor or to enforce. So the public, rather, even the Chief Justice criticized the public protector for some of the language. But he says this, if the public protector, quote, is of the opinion that facts disclose the commission of an offense, she is empowered to notify the prosecuting authority of what in her opinion, rightly or wrongly, constitutes the commission of an offense. Nothing in section 64C1 limits her to the type of class or offenses that she is permitted to notify the NPA about. Even murder or robbery may be brought to their attention. The fact that she does not bear the primary responsibility to investigate criminal offenses or not expressly empowered to do so does not mean that she may not look into and subsequently refer to the relevant authority any offense that is intertwined with allegations of unethical conduct that she is otherwise entitled to investigate. Is that how you understood the obligations of the public protector in relation to criminality? And would you like to explain that referral power?
Yes, that is how I understand it. And as it were here, we're not being prescriptive, except that when we do a remedial action, we have to have a monitoring of remedial action. Maybe that is why it sounded like the PP was now prescribing to the MPA on their reporting back on the possible charges that they would have preferred.
Yes, thank you. And then he says at 197, the allegation of money laundering and CR17 campaign are not divorced from the donation of the public that the public protector was asked to investigate. It is an integral part of that investigation. This is so because the source, the donation, is the same. They are virtually identical in nature and character. Honorable Maimane's concern, and we are intending to call Honorable Maimane to, well, he's no longer honorable now, to call Mr. Maimane to give the perspective of what it is that he was, but the committee yesterday had some views about it. But if eventually they allow him to come, he will put a perspective of what was behind his complaint. Because isn't it important, Mr. Matabuche, always to remember that, sorry, I almost said you guys, but that the people at the Public Protector's Office do not go around fishing for these things. Someone complains to you and that's how you take it up.
Yes, and we always say you must be true to the complaint when you investigate.
Sorry?
We always say you must be true to the complaint, meaning
Okay.
that was lodged with the
Yes.
office.
And then he then says, this is so, okay, Honorable Maimane's concern in this regard was about how the donated money moved through several intermediaries. It was therefore during and after the investigation of the donation to the CR17 campaign that she formed an opinion that the president might have committed money laundering. And this falls squarely within her section 64C1 powers. Then regarding the issue of, this is an issue I raised with your colleague, Ms. Mvuyane. This is about how, what brings us here really, what the Chief Justice called the magnification of the public protector's errors. In other words, he understands that you and the public protector might have made errors, but he says that they get magnified. And he quotes the judgment that I was referring Justice Ms. Mvuyane to. He says, 198, the following wisdom-laden words of caution by Madlanga J encapsulate the concern I have about the treatment of matters involving the public protector. Advocate Busisiwe Nkwebane particularly have findings and recommendations or remedial steps. Although the context was different, the message or principle is just as opposite and telling in all other cases. There, Madlanga J said, and I quote, there appears to be a developing trend of seeking personal cost orders in most, if not all, matters involving the public protector. Courts must be wary not to fall into the trap of thinking that the public protector is fair game for automatic personal cost awards. Whether inadvertently or otherwise, the High Court judgments in EFF Godan matter and in the instant matter are instances where the High Court fell into that trap. He says, I voice these words of caution because of the disturbing frequency and irregularity of application for and awards of personal costs against the public protector. What is particularly disturbing is that it is clear that the applications and awards are not always justified. Then says the Chief Justice, there is indeed a disturbing tendency by some of us to presumably without intending undue harm or injustice, unduly magnify virtually every error of the public protector, real or mistakenly perceived. This is quite surprising because judges with more experience as practitioners before their elevation to the bench and with more years of service as judges than the 10 years minimum requirement as an advocate or the mere fact of being a judge, regardless of how long to be appointable as a public protector, have committed similar or more serious errors and were not as harsh on them, or should I say on ourselves, and rightly so. And then in probably one of the most acts of self-effacing Christianity, which he is our former Chief Justice, he makes an example against his own interest, where he was castigated, rightly so, by the Supreme Court of Appeal for having sat as a judge in a case where his wife was the prosecutor. And this is the kind of thing that he says he was never impeached for. He says, by way of example, I presided in a matter in which my wife was appearing on behalf of the state, and that was S versus Dube. The Supreme Court of Appeal correctly and most courteously held that I should have granted the recusal application necessitated by the very appearance of my wife before me. As an aside, in this committee, that kind of thing is not, if Justice Mogoeng was here, he would have been fine. And then it says, Harams J.A.'s son appeared before a Supreme Court of Appeal panel of which he, the father, was a member. And so did Chaskalson P.'s son in this court. With the benefit of hindsight, I have realized that a reasonable apprehension of bias would most likely be entertained in matters of this kind. Each of us should therefore have recused himself without the need for an application to that effect. As judges, we should therefore always be alive to the reality that the elevation to the high judicial office does not have the inherent consequence of clothing any of us with a mantle of infallibility. For this reason, when we criticize others, we would do well to be alive to our own fallibility. But more examples are necessary to drive the point home. So what the Chief Justice was saying was, do unto others as you would like to be done to you, which most people should adhere to. He says, now this goes to a case that Ms. Mazzoni has presented to this committee for castigating the public protector. That is, you'll find that in the charge sheet, Chairperson, the addendum of Ms. Mazzoni. It's the case of Commissioner for South African Revenue Services versus Public Protector, the High Court one. It's number 5.2. This is where probably the worst example where the judge basically insulted the public protector. Says the Chief Justice, without any basis in fact or law, Mabuza J concluded in Commissioner South African Revenue Services versus the public protector that the public protector had a, quote, proclivity to operate out of the bounds of the law, and, quote, a deep-rooted recalcitrant to accepting advice from senior and junior counsel. And this was cited as proof of her unreasonable, arbitrary, and malafide conduct. He went on to order punitive cost against her in her personal capacity, a shocking and most unjust decision under the circumstances. Similarly, in Kabinde, this court held that 2 of its members had erred. What all this means is that the manner and extent to which judges and magistrates criticize litigants, legal practitioners, and witnesses should be a mirror image of the same measure of criticism they would find acceptable under comparable circumstances, when it were to be meted out to them by their colleagues, the practitioners or the public, who must therefore do to others as we would have them have others do to us. Then the last one, he says, that said, I'm also concerned about the notion that she somehow amended the code without authority. This is one of the charges here. I think hers was more of giving a wrong meaning to a legal instrument than amending it. But returning to the thrust of my concern, I cannot be correct to brand virtually everything she did in line with her constitutional and statutory duty to expose and help root out unethical conduct as shockingly wrong and worthy of strong criticism and outright rejecting. That, in my view, constitutes the magnification of her errors that courts should, as a way of distinguishing themselves from the media, commentators or analysts, the general public, or the so-called court of public opinion, be deliberate and intentional about steering clear of. After all, that is what fidelity to our oath of office demands of us all the time. It bears repetition that all litigants, practitioners, and witnesses deserve only the measure of criticism that we as judges and magistrates would be happy to be recipients of under similar circumstances. And that applies with equal force to the public protector. And then his conclusion is, therefore, I therefore support the main judgment only to the extent that it is reconcilable with these reasons. In sum, I uphold the appeal, make no orders to cost, and so on. That is the end. Do you remember those portions, Mr. Matabucha?
Yes, I do, Advocate Mpofu. I remember them, yes.
Yes. Yes. So that judgment, what can you, before I let you go, what can you, in terms of the 2 approaches, to what extent, and I want you to say this in your own words, does this judgment then at least vindicate or reflect your true approach, as opposed to the one that says that you were out to get Mr. Ramaphosa, and the facts, the real question I want you to answer before you go is, how does it make you feel to be accused of the opposite to what the Chief Justice says you were doing?
It is still disappointing. It was disappointing because I need to take a step back and go back to the time the judgment was announced, because as part of the internal process, whenever judgments are given, our legal services meet with the investigators and take us through the basis for the review and the judgment that was passed. So when the High Court judgments were being passed, we kept on going to the conference room to discuss the judgments. And part of my take when I was asked to respond was that I can't wait for the day the Constitutional Court passes or puts a weight to the investigation. Then after the Constitutional Court judgment, I would then feel, even if it would be to the negative, I'd only accept what the Constitutional Court would have ruled on the investigation. As part of the investigators, we were all in the conference room, and I said, until the outcome is there by the Constitutional Court, I'll still stick by the report. And when this judgment came out and the minority judgment was read out, I still said to the team and the colleagues to say, at least there's one voice of reason for us as investigators, one thing that has come back to pep me up and put back my self-esteem as a chief investigator. And that is how even today I still stick by the fact that not all that was done by me and the team and the people in this investigation was lost, because at least somebody saw what we did as not being as bad. Had it not been maybe for this minority judgment, I'd be very, very much, you know, I don't know if I may use the word despondent and very discouraged as an investigator.
Yes. No, thank you. God bless Mogoeng CJ. And were you ever, as part of this alleged conspiracy and vendetta against Mr. Ramaphosa, alleged and in brackets non-existent, were you ever charged at the institution where you are now? Did you ever face any disciplinary action, or is it just the public protector who's supposed to be the only member of that conspiracy who must be removed from her office? In other words, or maybe let me put it this way: if it was a genuine concern to assist the public, if it was not a witch hunt against a defenseless Black woman, to get rid of the public protector for ulterior purposes by powerful forces, would it make any difference to just remove her from office and leave the likes of you and Ms. Mviana and the others who are allegedly part of this nefarious conspiracy untouched if you were not charged? If you get what I'm saying. Maybe the first question, were you ever charged or accused of any wrongdoing?
No, I was never charged, but the atmosphere in the office when this thing happened, as an investigator, you get to be looked down upon by your colleagues, and as if you've misled, and you become a bit of a leprosy, in the office. Yeah. But I was never charged.
Thank you. And in your social life, for people who know that you are involved in such a high-profile and important job for the country, how does it make you feel when you then get lambasted as some vendetta-driven conspirator?
No, it affects your image and your profile in the public space, especially when one comes from a background of a university and where we had colleagues that are also practicing, somehow in high positions. It impacts on your person somehow negatively.
Thank you. So from the hateful, cruel, bigotist and prejudiced people who want to hold, to get rid of the public protector, do you think that anyone cares about quote unquote collateral damage to that mission, such as yourself and the other people who then get socially castigated and hurt in the manner that you have expressed?
Maybe if they had a chance, they would come for us as well, I think.
I agree. Thank you very much, Chairperson. As they say, one day they come for the communists, one day they come for these ones, and I keep quiet. And lastly, one day they will come for me. So I hope they never come for you, Mr. Matabuche, but I think you have the sympathies of the majority of South Africans and right-thinking persons. At least you have the sympathies of and the rational support of the Chief Justice of this country. Thank you, Chairperson.
Thank you. On that note of the former Chief Justice, we are going to pause for the day.
I still call him the CJ.
The meeting will be adjourned and we'll meet tomorrow at 9. Thank you. Meeting adjourned.
Thank you, Chairperson.
Recording stopped.
Long live the